All right. We are now streaming live on YouTube.
Okay, can we have a roll call, please?
Yes. Give me 1 second, Counselor. Let me just turn off my other screen, the YouTube screen. Give me 1 sec. All righty. Counselor Cassett.
Here.
Counselor Chavez.
Here.
Counselor Lee Garcia. Counselor Michael Garcia. Counselor Lindell.
Here.
Counselor Rivera, I know, is excused. Counselor Romero-Worth.
Here.
Councilwoman Villarreal.
Present.
And Mayor Weber. I think he mentioned he was going to be hopping on shortly. And we will call, I believe Councilor Lindell called this meeting to order. We'll put 1:05.
Correct.
There we go.
All right, we're starting with legal. I'm going to turn this over to Ms. McSherry. She's going to talk about city government structure, and then she will also move into, well, she and Marcos will move into Ethics and Open Meeting Act and inspection of public records. So, Ms. McSherry, will you go ahead and proceed with city government structure?
I will. Thank you, counselors. And just as a little prelude, this is meant as a refresher for those of you who have had some of this training before, but I've tried to add to it, and particularly in anticipation of our charter commission, which will happen later this year. It was a nice refresher for me too, to go through all the charter amendments that have happened in the last few years, to refresh my memory on those and how we came to the place we are now in terms of our city's structure. So I'm going to be sharing a presentation. And Marcos Martinez, Senior Assistant City Attorney, is here to help out with the ethics portion, and Jesse Gian will be helping out later with our updated procedural rules and our legislative process. Start from here. And I think we're going to try to build in some breaks as it makes sense. And I think if this works for you, Councilor Lindell and counselors, if you have a question, I think we can answer questions as we go along. That might work best. If there's a relevant question, we'll also, I think, pause in between each of the sections to allow for questions at that time.
That sounds good, Ms. McSherry.
All right. Okay, so I'll start with the government structure. Then Marcos is going to do the ethics rules and related laws. I'm going to talk about our sunshine laws, which are the Inspection of Public Records Act and the Open Meetings Act. And then we're going to do some parliamentary procedure overview and updates on our legislative process and rules. So we are a home rule charter municipality. Not all municipalities in New Mexico are, and in fact, only a few are. Albuquerque and Santa Fe are, which means that we've created our own form of government pursuant to a charter adopted by our voters. This was not always the case. We adopted it in 1997. It's only a 16-page document, so I do recommend people look at it every so often and refresh your memories as to some of the policy statements that are in there, and also as to the various powers and duties, because this really is what sets up the backbone for our government. So it also includes requirements for environmental protection, ethics, human and civil rights, cultural and neighborhood preservation, campaign finance and campaign practices, the general plan, and support for local business. So those are a framework for some of the areas that our population has told the government that they agree are important and should influence our decision making as a group of policy makers. This is somewhat of just a diagram that shows how the city's government is a little bit different than, say, the state government or the federal government. At the state and federal level, there's not really the overlap that we've created in our charter. So in our charter, for one, there's a legislative and executive overlap, and there's a legislative and judicial overlap. So our legislative body sometimes serves in a quasi-judicial role, which is not something that our state legislature does, or that I guess Congress can do it if they're having an impeachment trial, perhaps, and that type of thing. But it's not often that they sit in that posture. And the mayor also has a role that's pretty distinct from our governor or the US president, in that he both serves in the legislative role and in the executive role and in the judicial role. So he actually has all three. It is good to note that our judicial powers in the city are pretty narrow. They're only criminal. It's only a criminal jurisdiction. There's not a right to file a civil lawsuit in our municipal court between two private parties. It'll always be the city versus an individual or a business. There won't ever be a private party that decides to file a cause of action with our courts, with our one court, our municipal court. And then also it's limited in terms of the level of criminal offense that can be adjudicated. We can only go up to a misdemeanor. So anything that's a felony is adjudicated by the state, by the district attorney. The city prosecutor only prosecutes misdemeanors, and only those that are described in our city code, which is not all misdemeanors, but there are quite a few. So our charter has been amended 4 times since 1997, most recently in 2020, but that was a rather technical change. In 2008, we changed some of the election requirements and petition and signature numbers, and we required our municipal judge to be a licensed attorney, which wasn't the case before. In 2014, we adopted ranked choice voting and a strong mayor structure, and we added to some of our policy statements, particularly the environmental protection policy statement, the neighborhood protection policy statement, and the public financing of campaigns and local economy support. So we added several of those to make them stronger, essentially. And when I say we, the city as a whole, the residents, first the governing body reviewed proposals by a charter commission and then adopted certain ones to go on the ballot. And then they were adopted by our residents. The most recent substantive changes were in 2018 when we adopted the local election acts November elections rather than March. We used to have elections in March, and now officers assume office on January 1st rather than March.
Erin,
So-
quick question on this.
Yeah.
So when it was implemented, I thought there was a grace period. So like ranked choice voting, strong mayor structure in 2014, but it actually didn't get implemented for 4 years after. I can't remember the time.
Yeah, it's a great question. So on some of them, so particularly for the ranked choice voting, there was some specialized language there for implementation that talked about having the right resources in place or technology in place to accomplish it. So it didn't have a specific date attached with it, whereas some of the other ones do. And that can be set as part of the actual provision, the actual vote that's proposed. So they can, I don't know if there's any limitations on how quickly they could go into effect, but they certainly can have a future date associated with them. So it's similar with the mayoral salary. It was set at a certain, I think 70-something thousand per year until the time that an independent salary commission could meet. And so one of the changes with the strong mayor was requiring an independent salary commission. So we had to adopt an ordinance that allowed for that salary commission to exist. And then they had to meet and go through their process. So that one also had essentially, the timing was based on when we could get these other things in place. The Local Election Act went into place pretty quickly. So we adopted in 2018, and then we used it in 2018. And then the 2020 change was really somewhat of a technicality because we had a reference to Municipal Election Act. I mean, we had a election code, municipal election code, and the Local Election Act is now what we're using for our framework for elections, which is what that's what changed the oversight from our municipal clerk's office to the county clerk's office in terms of enforcement of a lot of the laws there. We still run our public financing, and that's been one of the things that also was strengthened in 2014, was essentially requiring a more robust public financing structure that we implemented after that. So let's see. What I've done on the next couple slides is I'm just highlighting the role of governing body, mayor, and city manager, and the changes that have been made to those three sections most recently. So the blue here for governing body's role is what was amended in 2018. And the primary change was that there was this specific call out of considering the legislative agenda put forth by the mayor. Because one of the mayoral changes, as we'll see in a minute, was to put forth a specific legislative agenda. So basically, the primary roles of the governing body to serve as the primary policymaker of the city, amend existing policies consistent with law and the charter, consider a legislative agenda put forth by the mayor and propose amendments to existing policies and propose new policies, provide for exercise of the powers and for the performance of all duties and obligations imposed on the city by law. So we might have duties imposed on us by the state or by other sources of governance. By ordinance, fix the salaries of the municipal judge and counselors and review those not less than every 4 years. That's probably something we should see if we've done within the last 4 years. I'm not sure if we have. I'm not sure we've done it since I've been here. So that would be a good note for us to take from this. Establish independent salary review commission. So we have done that, and they'll need to be meeting, I think, in a year or two for the next mayor. Set a policy for reimbursement of the actual and necessary expenses incurred by the mayor, the municipal judge, and city councilors. That's not something I've looked at recently. I might want to look at it. But certainly the salaries, probably we need to see when we've last reviewed those. I'm having to move around the various pieces on my computer here. The mayor's roles have changed pretty significantly in the last few years. The green in the first bullet here, that was an amendment made in 2008. Oops. But the blue was all part of the 2014 to 2018 changes that went into place. So we added that the mayor would be full-time. Previously, the mayor had a vote on tie matters and then a vote when it was required to bring something forward before the governing body. So then in 2008, we gave the mayor a vote on all matters. And then in the 2014 to 2018 period of time, we added that the mayor would be full-time, that the appointments were there previously for city manager, city attorney, and city clerk, but the language of consent is new. And then there used to be language about, well, there was language about removal in the governing body, and then that was removed. The language about administrative and supervisory control over the city manager, city attorney, and city clerk were added, and the authority to remove all three was added without a need for a vote from the governing body. So as the executive, his authority and role is to make sure that our ordinances are obeyed and that we are fulfilling the requirements in our ordinances. And he has, and this is very much in relation to the emergency powers relevant, that he has the power conferred on sheriffs of counties to suppress disorders and keep the peace. So that ties into our emergency authorities and powers in our ordinances about declarations of emergency and the orders that are made pursuant to those proclamations. Not to necessarily literally read all these, but represent the city in intergovernmental relationships. That comes up a lot. The annual State of the City message, and working to prepare. So assigning the budgetary proposal to the mayor was new in the changes between 2014 and 18 of working with the city personnel to prepare a budget. And these last two were in there for a while, representing the city government ceremonial purposes and be recognized by the governor for purposes of military law. The city manager's role is mostly fleshed out in ordinance. In the charter, it's very basically stated as follows, being the chief administrative office of the city, hire and firing all city employees except for the city attorney and city clerk. And that was an addition in more recent changes to the charter, and having such other powers as provided for in city ordinances. And that's where really the city manager's role is fleshed out quite a bit in the ordinances. So that's the structure to kick us off. Any questions on that? I do definitely recommend at least once a year, if not more often, going through the charter and just refreshing your memory as to what's in there, what's not, particularly this year, because we are going to have that charter commission coming together, and the types of things that they would want to look at. But the structure of our voting is in there, how candidates get on the ballot, how many candidates we even have, right? The fact that we have 8 city councilors is established in the charter. The fact that we have 4 districts is established in the charter. All those things. So these are some of the basics to it, but there's more as well. Like how do we citizens' right to referendum and initiative are in the charter as well. So those are things we don't see very often, but they are possible. Councilor Villarreal, I see that we've got Mayor Weber here again. Mayor Weber, do you want to call on people? Do you want me to? How do you want to?
I think you're doing great.
Okay. All right. Councilor Villarreal, did you have something?
Just a clarifying question. There was a line that said the legislative agenda is put forth by the mayor. So how does the charter define legislative agenda? That was confusing to me.
It actually doesn't really define that term, but I think the idea is that the mayor can have a package of legislative proposals, and that's contemplated in the charter that he would come forward with.
Policies for the city.
Right.
And then I guess it made me also think about legislative agenda. It's not really an agenda, but like what we put forth to the legislature. I don't think that's a correlation, but I'm just thinking of the term. That's not referencing that, correct?
I would agree with that. I think what it's talking about is proposals of ordinances and resolutions for the city in terms of policy packages that would come from the executive branch, essentially. Yeah.
And does it say also the same thing for councilors?
I think the first. Let me go back to I'll pull it back up here and go backwards. Some of the yes. So in the governing body's role, serve as the principal policymaker for the city. So that definitely contemplates bringing forth bills and resolutions, and both bringing forth them and amending them, which is that second bullet.
Got it. Okay. Thanks for the clarification.
Sure thing. Yeah. Councilor Lindell, did you have?
Yes, I do. Thank you very much. Could you be sure that on all the documents that we go over today, that these are forwarded to members of the governing body?
Absolutely. Yes.
Thank you.
For sure. I think we'll also send some links just so people have some quick links to the charter and to some other of the references that we're making reference to, but we're not going through every section of the charter, but I do think it's just nice to go there on a frequent basis and check back. It's in the same place with all of our ordinances. On the main web page, if anyone's following along, but the main web page for the city, if you go to leadership and laws, the code is linked directly from the main page under that menu item. So any other questions on general structure and charter for the city? And if not, then we'll go to Marcos and he'll do the update on ethics. All right, this is basically, we're doing our annual ethics training through this.
Thank you. Thank you. Well, I'm going to share my screen as well. So let me pull that up so that you can follow along. It's bigger. Okay. Can everyone see that? The screen? Okay. Thank you. So I'll just read from this quote here, first presented by me, Marcos D. Martinez. I know most of you. I don't know you. Councilor Chavez, it's nice to meet you through this Zoom forum. I'm the Senior Assistant City Attorney. I'm going to just begin. I'm going to jump in with 1-7.6 because it says that each public official and public employee shall be given a copy of the Code of Ethics upon election, appointment, or employment, and shall sign a statement to the effect that the public official or public employee has received the Code of Ethics and understands that the public official or public employee shall abide by its terms and conditions. The City Attorney's Office shall conduct an annual review of the Code of Ethics for all public employees. Ethics, the principles of acceptable conduct. What is a code of ethics? It's from the Greek, ethikos, meaning relating to one's character. Black's Law Dictionary defines it as an officially adopted statement of the principles of acceptable conduct relevant to the activities of an occupational group, especially a professional one. The City of Santa Fe's charter, section 2.01, calls for a code of ethics. The city's ethics code is codified by city ordinance. It is online. Again, under leadership and laws, you'll find it there. There are also a few videos under the city attorney's page, I should make that clear, where we dramatize some of these ethical issues. The other applicable ethics rules that you should be made aware of, or that I'd like to make you aware of, is that the Governmental Conduct Act applies to city officials. This is available at the New Mexico Attorney General's website and through other locations. So we'll forward this PowerPoint to you, and you can follow this link if you're interested. The Federal Hatch Act applies to some city officials, but it's a little bit unusual, so I won't go into that unless there's a question. This is ambitious, but I'm going to try to cover these. This is basically an outline in the form that the city code has, in the order that the city code presents the code of ethics. There are also personal rules and regulations and policies that might be relevant and touch upon ethics. And then, of course, there's the Governmental Conduct Act. I'll talk about that at the same time if it's appropriate, and try to be quick. But if anyone has a question, please interrupt me, and I'll try to answer it as well. So from now moving a little bit backwards, the section I read was 1.76 previously, but 1.72 says, 1-7.2 says that the proper operation of a democratic government requires the public officials and public employees be independent, impartial, and responsible to the people. The governmental decision and policy be without conflicts of interest, the public office or employment not be used for personal gain, and that the public has confidence in the integrity of its government. And that policy, I think, is excellent. Well said. So the purpose and intent section: to fulfill the obligation imposed on the governing body by the Santa Fe Municipal Charter to establish standards of ethical conduct for public officials, employees, and provide consequences if violated. Again, the purpose and intent also adopt standards to ensure decisions are made without consideration of personal benefits, to provide clear guidance as to what is allowed and not allowed, to advance openness in city government through disclosure, to exercise legislative powers granted under the state constitution, and adopt a code of ethics to meet local concerns and needs of Santa Fe. And so if the code of ethics on your review is not as clear as it could be, I think it would be great to let us know that, because we do want the guidance to be clear as to what's allowed and not allowed. And if it's not accomplishing that, we should work on that together to try to make that goal achieved. I think one of the biggest points with the code of ethics is what's a conflict of interest. And I think this phrase gets thrown around a lot. So let's look at what the code says. You have a conflict of interest if your official act will result in a specific and identifiable prospect of financial gain or loss to yourself or one of the entities listed below. And by entities listed below, I have any member of your family, any business you or any member owns, any employer, client, or customer from whom you know or reasonably should know paid you or a family member more than $500 during the year preceding the official act. So let me begin with what's not included. The gain or loss that's de minimis. This is a small benefit that the public often receives in an amount shared or with a substantial segment of the general public. For example, you helped draft legislation that will reduce taxes for all the citizens of Santa Fe, and you are a citizen of Santa Fe. That is not a conflict of interest, even if you yourself are going to be paying less taxes or lower rates or lower fees, because it's benefiting everyone. What would be included? Going down, in my second example, if you were paid $501 to provide catering services during an event, the restaurant that paid you is now seeking a grant from the city. Your involvement with a grant would be a conflict of interest. Any civic group is included, though, a labor union that you're a part of, social, charitable, or religious organization of which the public official or public employee is a member, or a member of his household is an officer or director. So again, I guess that wouldn't be typical membership, but officers or directors. For example, if you're on the board for the National Dance Institute, NDI wants to hold a fundraiser on city property and is seeking a lease for city land for the event. You were to assist with the lease in your role as a city employee, well, more as a public official approving the lease. While working for the city, that would be a conflict of interest. An employee would likewise face a problem if they were helping draft the lease and then sending it up to the governing body for approval. Here's some other terms for conflict of interest and gift limitations. Financial benefit, what does that mean? It means under the code, any money, service, license, permit, contract, loan, travel, entertainment, gratuity, or any other thing of monetary value or any promise of these. Family is defined to include the members of an individual's household, his or her children, stepchildren, brothers, sisters, parents, step-parents, domestic partner, and all persons claimed as dependents on the individual's latest federal income tax return. And an official act, an official decision, a vote, an approval, and any acts that involve the use of discretionary authority. What do you do if you have a conflict of interest? These do arise. Everyone typically has outside employment. Members of the governing body do, the city council at least. So this happens. In the case of a member of a governmental body, to the governmental body at a public meeting, this is what you are to do. Number one, do not vote on the matter to which you have a conflict of interest. However, if compliance with the conflict provision by a public official would deprive a governmental body of a quorum for taking necessary action, and it is deemed an emergency, the public official shall be excused from such compliance when he or she has made the disclosure required. So as an example, in a special governing body meeting to approve the purchase of emergency equipment in which the vendor is related to a member of the governing body, the public official to maintain a quorum may vote to approve the purchase. The public official should disclose the conflict at the meeting and explain the exception that applies. So what this is meant to do is to illustrate what your official act is. If you know you have the conflict of interest because there's this prospect of financial gain or loss, there's someone in your family who might be related to the person seeking permission from the governing body, that would typically be a conflict of interest and you would recuse yourself. There's also now some with the recently adopted procedural rules, I should just make a note of this. I believe there's some debate over whether one needs to disclose the nature of the conflict itself. I don't think that is required under the new governing body procedural rules. Aaron can correct me if I'm wrong. I think that's discretionary up to the official, but you do identify that there is such a conflict and you recuse yourself typically. This is an example which I provided in which you would still be able to proceed and take official action, but because of an emergency, it's excusable, and the disclosure also cures the problem that the conflict of interest provision is seeking to avoid. So required disclosures. Public officials, the mayor, the councilors, the city manager, the city attorney, the city clerk, and department heads are required to disclose the following to the city clerk: name, address, and telephone number, employer if other than city, the city, professional, occupational, business licenses, memberships on boards of directors of corporations, public or private associations or organizations, and businesses that they own. One would do this every year. And this is also a requirement of the Governmental Conduct Act. So that disclosure is there whether it was in the city code or not. Improper gifts. Generally, gifts in excess of $50 are not allowed, but there are exceptions to rules against gifts. An occasional meal or non-pecuniary gift with a fair market value not to exceed $50, that's fine, no problem. If relevant to the performance of his or her official duties, members of the governing body, the city manager, the city attorney, or the city clerk may receive an occasional non-pecuniary gift not to exceed $250. Someone wants to give you a Nambe vase. Hopefully it's under $250. You can accept it. An example that it would not be a gift. If the city provided personal protective equipment during the pandemic to everyone who came into the library or city hall, these are not gifts. They're available to a substantial segment of the population. The Gift Act for state actors is very similar to this. Our provisions basically mirror those limitations in the Gift Act, but the Gift Act, just to be clear, is not strictly applicable to city councilors or the mayor. After the fact discovery, sometimes people discover things after the fact. If you've received a gift or other financial benefit within the last calendar year and then discover that the gift giver has a prospect of direct or indirect pecuniary gain or loss from your official act or acts, you must return the gift, or you have a conflict of interest and must disclose the gift and not take the official act as provided by the conflict of interest rules. Improper transactions with the city. So this is basically, this is something that comes up after someone is no longer a councilor, mayor, member of the governing body, city manager, city attorney. Elected officials shall not accept paid employment from the city of Santa Fe for a period of 1 year following the leave of public office. Public officials shall not enter into a contract or transaction with the city of Santa Fe during his or her term of office for a period of 1 year following the leaving of public office when the contract or transaction is a result of an official act by that public official. So there's a similar provision in the Governmental Conduct Act. Here it states that a local government agency, and that is defined as to include the city, shall not enter into a contract with or take any action favorably affecting any person or business that is, one, represented personally in the matter by a person who has been a public officer or employee of that local government agency, let's just say the city, within the preceding year if the value of the contract or action is in excess of $1,000 and the contract is a direct result of an official act by the public officer or employee. So the Governmental Conduct Act in some is a little bit looser than the city's provision. So if it were a small contract with the Governmental Conduct Act, you wouldn't have to, it wouldn't be an improper transaction. Under our own ethics code, it's a little more strict. There's a second provision here too. You shall not enter into a contract with or take any action favorably affecting any person or business that is assisted in the transaction by a former public officer or employee of that political subdivision of the state whose official act while in employment with that political subdivision of the state directly resulted in the agencies making that contract or taking that action. Moving on, misuse of confidential information. Public employees shall not use or disclose confidential information when he or she knows or reasonably should know that the use or disclosure will or may result in a financial gain or the avoidance of a financial loss on the part of any person or entity other than the city. What is confidential information? It means information which is acquired through public employment, which has not previously been made public, and which is not required to be made available to the public under the Inspection of Public Records Act. The Governmental Conduct Act has something very similar as well. I won't read that to you, but it parallels what the city's provision states. Misuse of city resources. A public official or public employee shall not use city services, personnel, or equipment for personal benefit, convenience, or profit, except when such use is generally available to the public. For example, public officials may not use the city's vehicles for private use. That's easy. By contrast, anyone, including public officials, can use publicly available Wi-Fi provided by a public library. No problems there. Nepotism. Public official or public employee shall not perform any act to obtain the employment or influence the employment by the city of a member of his or her family. No public official or public employee shall serve as the immediate supervisor of a member of his or her family. Again, State Governmental Conduct Act also prohibits nepotism.
Marcos, can you remind us what the definition of family is for that purpose?
Yes, it's, let me see, it's a few slides back, but let me read it to you. Got it here as well. Members of the individual's household, his or her children, stepchildren, brothers, sisters, parents, step-parents, domestic partner, and all persons claimed as dependents on their tax returns. So, I don't know, broader than the nuclear family, I guess. Financial disclosures with subordinates. A public official or public employee shall not knowingly require, expressly or impliedly, or authorize another person to require that any subordinate of the public official or public employee engage in a non-official financial transaction, including a personal loan or charitable contribution. This has never come up at the city to my knowledge, but I'm sure there was an interesting story as to why this law was necessary, where an employer was collecting basically contributions from their employees. Improper campaigning. Oops, I skipped ahead there. A public official shall not knowingly request or authorize another person to request that any subordinate of the public official to make a campaign contribution or provide services to a political campaign, and shall not engage in political campaigning while on duty for the city, or use city funds, supplies, vehicles, or facilities to benefit or assist a political campaign. This is similar to what the Governmental Conduct Act states. I won't read it to you because I believe all the elements are covered by ours. I guess what's more specific is in B, threatening to deny a promotion or pay increase to employee who does or does not vote for certain candidates, requiring an employee to contribute a percentage of the employee's pay to a political fund, influencing a subordinate employee to purchase a ticket to a political fundraising dinner or similar event, advising employee to take part in political activity or similar activities. I mean, I think these are just good guardrails, and I think that makes sense. City employment as a political reward. Public official shall not promise an appointment for the use of his or her influence to obtain an appointment to any position with the city as a reward for any political activity or contribution. Example, a candidate for public office cannot promise to make a contributor deputy city manager for working on their campaign. Similarly, the Governmental Conduct Act says that no legislature or public officer or employee may request or receive, and no person may offer a legislator or public officer or employee any money, thing of value or promise thereof that is conditioned upon or given in exchange for promised performance of an official act. That's a 4th degree felony. Here, it almost seems like it's as if the bribe were coming from the employee potentially. So both directions are covered. The Governmental Act in this provision at least does apply to the city governing body. Let's see. Here we have honoraria. Beginning with our code, the public official or public employee shall not request or receive an honorarium for a speech or service rendered in the performance of his or her duties as public official or public employee. Honorarium is defined as it means payment of money or any other thing of monetary value, but does not include reasonable reimbursement for meals, lodging, or actual travel expenses. So just remember that you're asked to, go to Colorado to talk about home rule charter municipalities. They can pay for your meals, lodging, and actual travel expenses in making a speech or rendering a service. That's not prohibited. Reimbursement for travel is considered a gift, however, and must be reported to the city clerk according to the code's gift reporting rules. Under the Governmental Conduct Act, honoraria valued in excess of $100 is prohibited. And they have a very similar definition as ours. Bullying by governing body members. So I think just by way of background, I'm going over this because it is covered in the code, but also I just want to point out that other parts of the city code that are not specifically in the code of ethics kind of bear on these provisions. And so one portion of the code to bear in mind that I haven't listed here is section 2-4.8. I was talking to Erin about this earlier, and I think she reminded me to talk about it. basically the governing body works through the city manager. I'm just going to read this section to you, and forgive me for not putting it in the slide yet. The mayor and the members of the city council shall deal with department heads and employees of the city solely through the city manager. Neither the mayor nor member of the city council shall give any order directly to any department head or employee, either publicly or privately. So I think this is in part due to the fact that the charter kind of establishes that the city manager is the head of personnel. So then building on that, the code basically specifies that one works through the city manager, who then kind of coordinates with the department heads. Of course, you can talk to all of the city employees. There's nothing wrong with that. And the same provision says that if any councillor or the mayor wants any kind of information that would be otherwise available to members of the public through IPRA, they don't need to go through IPRA. They can just talk to the employee who has the information requested, and the employee can provide it. That's not giving orders. That's just part of the functioning of government. We're talking about sort of specifically directing the particular work of an employee, which again, I don't think is an issue. Then now going back to the code of ethics, the city passed this provision and made it part of the code of ethics. A governing body member shall not intentionally bully an employee, including the city manager, city attorney, or city clerk. Workplace bullying means intentional behavior intended to create an abusive work environment for a public employee or public employees. Bullying behavior is behavior in the workplace that a reasonable person would find hostile, offensive, and not obviously related to the city's legitimate business interests. Workplace bullying includes, but is not limited to, the following: use of disrespectful and devaluing language, persistent or constant criticism in front of others, including coworkers, vendors, contractors, or members of the public, for the purpose of humiliating an employee. Behavior or language that frightens, humiliates, belittles, or degrades, including criticism that is delivered with yelling and screaming. Threats and intimidation, including threats to discipline or terminate an employee. So then, on a related note, retaliation and whistleblower protection. Employees shall not be retaliated against for filing a complaint of violation of the code of ethics or any other law or requirement, providing evidence, or participating in an investigation of any such violation. Retaliation includes dismissal, threats of dismissal, or otherwise singling out an employee. Then I should note that the Whistleblower Protection Act is a state law, and it creates a civil action for retaliatory actions. Public employer shall not take any retaliatory action against the public employee because the public employee A communicates to the public employer or a third party information about an action or failure to act the public employee believes in good faith constitutes an unlawful or improper act, provides information to or testifies before a public body as part of an investigation, hearing, or inquiry into an unlawful or improper act, or objects or refuses to participate in an activity, policy, or practice that constitutes an unlawful or improper act. Imagine a scenario that doesn't exist in the city where someone wants you to do something that the employee believes to be unlawful. That employee basically can refuse to participate in that action, and the employer, the manager, couldn't in those cases retaliate against that employee. Not speaking to any particular instance that I'm aware of, but I'm just trying to illustrate what this is meant to protect and cover and warn us all against. So going to the Governmental Conduct Act, I've made a lot of references to that through this presentation, but I wanted to just highlight a few other portions that we didn't touch upon. I think some of these are also good policy statements. A public officer shall treat the legislator or public officer's government position as a public trust. The public officer shall use the powers and resources of public office only to advance the public interest and not to obtain personal benefits or pursue private interests. Public officers shall conduct themselves in a manner that justifies the confidence placed in them by the people, at all times maintaining the integrity and discharging ethically the high responsibilities of public service. Full disclosure of real or potential conflicts of interest shall be a guiding principle for determining appropriate conduct. At all times, reasonable efforts shall be made to avoid undue influence and abuse of office in public service. And the last one is something I had already read in a different section of this presentation. So now contracts involving public officers or employees. and again, this is the Governmental Conduct Act, not our Code of Ethics. Unless a public officer or employee has disclosed to public officers or employees substantial interest through public notice, again, disclosure will protect you to a certain extent, and unless a contract is awarded pursuant to a competitive process, the city shall not enter into a contract with a public officer or employee of the city, with the family of the public officer or employee, or with a business in which the public officer or employee of the family of the public officer or employee has a substantial interest. Prohibited bidding. No local government shall accept a bid or proposal from a person who directly participated in the preparation of specifications, qualifications, or evaluation criteria on which the specific competitive bid or proposal was based. So again, you don't want, if you know someone out there who's gonna, maybe you know of a project that's eventually gonna go out to bid, you don't want to have the person who might meritoriously win the bid be made aware of it in advance and make suggestions to the team that's putting together the specifications, so that they're basically describing what will ultimately go into the criteria for the bid or proposal. And because that will disqualify the person who ultimately will bid on it and cause some problems in the future. So let's see what else we have here. So some penalties for governing the Governmental Conduct Act. They include criminal prosecution for most violations are misdemeanor and shall be punished by a fine of not more than $1,000 or by imprisonment for not more than a year, or both. For bribery, it's a 4th-degree felony. There's civil enforcement also available, a permanent or temporary injunction, a restraining order, or other appropriate order, including an order for a civil penalty of $250 for each violation, not to exceed $5,000. So we don't know which way those could go. The Governmental Conduct Act can be, I'll talk about who enforces next, actually. Suspected violations of the ethics code by public officials may be reported to the city's Ethics and Campaign Review Board. Any individual may submit a sworn statement. The city attorney may also bring a complaint to the board. The ECRB can issue opinions that are binding on the board. And just in parentheses, the CAO's advice is not binding on the ECRB. So this came up a little bit during the last election, whether the city attorney's office could opine on things, on issues that were present. We cannot, that authority has been delegated to the ECRB. Previously, before that provision was in effect, I think the city's attorney's office did opine on some ethical questions. Also, suspected violations of the Governmental Conduct Act may be reported to the Human Resources Department, the DA's office, or the AG's office under the Governmental Conduct Act. This provision I'm citing here, 1016-18A, and the State Ethics Commission, which is a newly constitutionally created commission, which is also providing some advisory opinions, and we've looked to those to see if we're interpreting, for example, the procurement code correctly. I think that's it, right or wrong. Submit me your questions there, and I'll stop. I wasn't paying attention to see if people had their hands up during the presentation, so I apologize for that. If I missed anyone, I can try to answer any questions you have now, or by email, or by call.
Marcos, I have a question.
Yes, Councilor.
So in that last slide, it said the city attorney could bring a complaint to the Campaign Finance and Ethics Board. And under what circumstances, I guess, would that happen? And is that maybe left to interpretation by the city attorney about when it's, I guess I just wonder, like, if it's important to the integrity of our campaign code and rules, is that sufficient, or is there some other level at which the city attorney would get involved?
That's an excellent question. We have not, the city attorney's office, since that provision's been there and I've been here, not brought any questions to the ECRB, but let me just pull up that provision and see if I can give you a little bit more of an expansive answer. I would think that under the complaint section, what it says is that I think that the city attorney's, it would be if the city attorney's office was made aware of certain information that probable cause existed of a violation of the code of ethics. That's basically the situation that I think, in which case, since the city attorney is not opining anymore, we would bring that complaint or that probable cause question to the board to see, and they would then determine whether a hearing is appropriate because there was probable cause to find that a violation had occurred of the code of ethics or a campaign issue, which is probably how it might arise. So,
Mayor Weber Marcos.
Yeah,
just
I
to
can
jump
tell
in on a
the city
couple
attorney's
things.
dying
Yeah.
to jump in here.
Well, I just know the operative verb there is may. So there isn't a lot of helpful guidance as to when it should happen because it just says may. So it doesn't say you should do it in this circumstance or you have to do it in certain circumstances, right? So there's it's not extremely directive in terms of like what is appropriate and what isn't. So there's certainly some discretion there. But certainly you would want to have enough or know enough, at least from what I have thought through in certain circumstances, that you'd want to be able to prove whatever. If you have a concern, you'd want to be able to prove the case essentially. And I think you'd want it to be important if you're going to bring it to that type of a forum. So those are the two things I've thought about in terms of that particular delegation of power. And I guess just to go back to, we don't have binding opinions. We can certainly make recommendations, but our recommendation would always say our opinion is not binding on this matter. So if you want something binding, which is if you're worried about something and you want to be able to rely on the advice in order to take certain actions in the future, then it certainly would be advisable to get that binding opinion that you can rely upon in the future.
I think this is an area we need to look at, is how we enforce our campaign finance and election code, and whether I just want them to mean something, and I want to make sure we're all playing by the same rules. And I didn't realize the city attorney could bring something to the Campaign Finance and Ethics Board. So that's sort of interesting. And I guess I would like to explore a little bit more under what circumstances you would find that may something that would cause you to jump in. So appreciate the explanation. And I think we need to maybe look at this a little bit and make sure that we may need to make some changes about how we enforce our rules to make sure we have a fair playing field. So sort of a comment and a flag of an area that needs some attention.
I think that's pretty interesting. Yeah, for sure. I don't know if the clerk has something on that too or not, but I think it is a complicated area in terms of roles and responsibilities as between the city attorney's office, the Campaign Ethics Review Board. We got a contract counsel to help out there just to help remove myself from that commission as much as possible this year, just for absolutely just appearance purposes. It's not required, but I thought it was a good idea. And so certainly we, I think, had to juggle some ambiguity there this year, for sure.
Can I follow up on that? Oh, go ahead, Christine. I'm sorry. I want to follow up though from Councilor Merriworth's point, but you go ahead, your hand's up.
Sure. I actually just wanted to kind of compliment Attorney McSherry's comments along those lines, that I think this year we learned a lot through the campaign process. And ironically, we actually had a standing ECRB code rewrite meeting scheduled at the same time as this orientation. So we are working proactively, and I think Marcos and I have both been in discussion with the ECRB about potential changes and just experience that we have from this year. So I absolutely look forward to working with both the ECRB and then the governing body as we move forward in that process, and appreciate the feedback. But I do just want to note that is in the works. So yeah, we're trying.
I was going to go into that as the next layer, so I'm glad you brought it up. There is a question that follows up from what Councilor Merriworth said about, okay, so a matter has been referred to the ethics board, what's the composition of the ethics board? And how is that selection made, and what are the criteria? And then within the ethics board, what are the ethics for the ethics board? What constitutes a conflict of interest within the ethics board? We are a very small community, and everybody knows everybody. And frequently, going back to Marcos's definition of family, there are links among family members. This becomes really a complex process of really working to promote public trust and confidence in our electoral process. So I support what Councilor Romero-Worth just said about digging deeper. I'm glad to know that there are these standing meetings and there's work in progress to review not just what constitutes potentially an ethical violation, but how that is adjudicated and who does the adjudicating, so that it becomes something that the public really has a sense of confidence and trust in their well-being. Their interests are being protected in a way that is consistent.
Thank you, Mayor. And I think one of the other examples that we're looking at is the State Ethics Commission, because that was created after we had created our own ECRB, and they have investigatory enforcement powers, and they set up their way they investigate things a little bit differently. So I think it's worth talking to them, looking at how they do things to see if it produces a better result, or maybe they're just things we can take that improve our own processes. Thank you.
Mayor Weber and Marcos, I just wanted to point out, so most of what Marcos also outlined would apply to almost all of our policy boards or our appointed boards. So they would have a lot of the same restrictions. There may be just a few places where we distinguish, but in most cases, they have the same restrictions.
But not to dwell on it too much, but we passed over pretty quickly over what constitutes. Well, Marcos did a nice job, but we didn't get a lot of Q&A around what constitutes a conflict of interest, and we got into the issue of, and we did the other night at the governing body meeting, about whether or not you're required to recuse yourself and then explain the reasons for your recusal. The flip side is, what if you say publicly, well, I do have a friendship or relationship or a family relationship, but that doesn't really cloud my judgment, so I'm not going to recuse myself. Nobody else gets to say, well, I disagree, I think you are compromised. It's self-evaluative, and the decision of the individual is the last court of opinion on that. I guess there's the court of public opinion, but there really isn't a secondary appeal to saying, well, thank you for not recusing yourself and assuring us that your judgment hasn't been impaired. However, I find that hard to believe, with all due respect. Where do we go? Where do those kinds of conversations ever occur? Marcos, I'd love your guidance.
I think they can actually occur with the ECRB. I think most people think of the ECRB as sort of a campaign or election board that exists or comes into being with an election and then kind of goes away. But the ethics code states that if you believe that someone has violated the code of ethics, which again is binding on all of these boards, not just the governing body, but it's the planning commission too, as well. It might be the arts commission. And someone says, I think you've got a conflict of interest, and they self-determine that they do not. Then I think you can file a complaint with the ECRB, and they can make a determination. So I think that question is excellent. And I think the governing body and all members of boards need to be made aware of the fact that it seems at first blush like it could be self-policing, but there is, kudos to the governing body for establishing the ECRB, because it exists at all times, even if it's not, it doesn't apparently seem to be constituted to answer these questions.
I'd like to add a little bit to that. In certain matters, if they're quasi-judicial in posture, so if it's a matter where people have individual rights, and if they believe their decision makers were compromised, that could be a basis for an appeal to the district court as well. That wouldn't apply in in many cases, but it could apply in some cases, particularly our judicial proceedings.
And I guess to add on to that, I mean, if it were really egregious, you also have the voters as a check, but that would have to be, that's a pretty high bar, I think, where the voters would take corrective action. And so again, I do think we need to look at this and pay some attention about how we enforce our campaign finance, because it goes to the integrity of those processes. And if some people get away with stuff and there's no consequence, no accountability, then why do we have the rules? So as long as we're talking about this, I just want to flag that this is something we should spend some time looking at outside of an election cycle.
Any other questions for Marcos? I think this is great. I think, and the fact that we're thinking about some of these big structural issues is great for this year too.
And you know what? I only have one other thing, which is I am curious whether we put too much responsibility in average citizens to bring forward complaints. And so I would be interested in how the State Ethics Board is doing that. I mean, I think sometimes people sticking their neck out in these instances, in the fact that we do live in a small town, is very difficult. And so I'd be curious, again, I mean, we can learn from other levels of government within our state. We can learn from other local governments around our state and outside of our state about what are best practices, how best do we look at this, and again, protect the integrity of these systems. So thank you.
Great.
Thank you.
I think that, Marcos, does that conclude your portion?
Yes, it does. I'm happy to stay around or yeah.
Sure. Either way, you're welcome to do either one. So I don't know if folks, should we go straight into the sunshine laws at this point? And then we'll do a break after that. Is that the plan? Okay. I'm going to be sharing my screen. The next two items on the agenda are our sunshine laws, which are the Open Meetings Act and the Inspection of Public Records Act. Okay. I think most of you are at least somewhat familiar, if not very familiar, with both of these acts. These are both considered to help the public have the greatest possible information about governmental affairs and official acts of officials and employees. And they're both codified in our state statutes, so these are not locally regulated. We could probably be more protective than these, but we probably could not be less protective than either of these acts with our city ordinances. So basically, the Open Meetings Act, its purpose is to ensure the formation of public policy and conduct of government business occurs in a forum open to the public. Figure out where to put people's faces on my screen in order to see the rest of the stuff. Basically, all meetings of a quorum. So for the governing body, that means 5. And for other entities within the city, it could be a different number. I know there's some public policy or policy making bodies that have 5 or 7 members, so their quorum would be different than the governing bodies. But the governing body's number is 5. That's the magic number. And if it's it's a meeting that's held to formulate public policy, discuss public business, or take action by vote. So it's not just votes, which I think is a common misconception. It's also just discussing public business. I think that's the broadest characterization. So basically, any time that there are 5 members of the governing body who are formulating public policy, discussing public business, or taking a vote, that meeting must be open, and the public, which means that the public must be able to attend and listen. So Open Meetings Act does not require public comment, but our own ordinances encourage public comment opportunities. Similarly, our own ordinances are more broad, well, our own policies are more broad than the Open Meetings Act with regard to which bodies the Open Meetings Act applies to. Our committee rules require that all of our committees follow the Open Meetings Act, and I think we've deviated from that briefly in certain contexts recently. But I think are back to all of our committees currently are required to follow the Open Meetings Act, even if they're not policy-making bodies. So we've gone broader than the state's Open Meeting Act in terms of the applicability. So we do have flexibility for those committees that are advisory. So if a committee is only advisory, the Open Meetings Act does not require compliance, but our committee rules do. So basically, if a majority of the members are together, or if they talk when they're not together, for example, in separate conversations, say 3 counselors speak, and then one of those 3 speaks with 3 more counselors, that's where we get the rolling quorum. And the rolling speaks to the idea is that not the whole quorum is together at the same time in the same place, but it forms over the span of time and place at different times and different places. Electronic quorums can be formed by emails, which means that more than 4 people from this body receive the same message from another one of the members, or it could be via social media, which could get quite complicated. I don't think we've had too many questions on that, but it would be the same as an email. So say one counselor posts about a subject that's happening and another counselor adds on and says, yes, you should come out and support this topic at our next governing body meeting. And then someone else shares that message and adds on, and then someone else comments again. If you ended up having 5 people participating in that on a social media site, whether it be Twitter or Facebook or Instagram or anything like that, that could cause the same problem. I haven't seen any allegations of that issue in New Mexico, but it seems like it could easily happen. So in order to comply with the Open Meetings Act, we have to provide reasonable notice of the date, time, and location that these conversations, these meetings will be occurring, which is why it's essentially impossible to do via an email meeting or a Facebook meeting, is because you can't invite the public into that conversation at a particular time, and we can't announce the agenda of that conversation in advance. So we are required to post an agenda at least 72 hours before, unless there's an emergency. There are special guidelines for emergency situations, and the agenda must list the items of business to be discussed. So for example, like today, we're not voting on anything, but we still had to identify the topics that we were discussing, alert the public that we were meeting, alert the public how to view and attend, but not necessarily, they didn't have to have the opportunity to participate in order to comply with the Open Meetings Act. And just a little note as well, there are other matters if they're certain land use cases, certain quasi-judicial matters that require more than 72 hours of notice. And that's usually required by either ordinance or statute, depending on what it is. Minutes, we have a variety of comprehensive levels of minutes within the city. We've had some that are almost verbatim transcripts. That is not required by the Open Meetings Act. It's certainly allowed, but it's not required. The Open Meetings Act only requires that we document the time, date, and place of the meeting, who was here, who was not here, which is why we keep track of when people arrive and depart if they're not at the meeting for the entire time. That's one of the requirements. The substance of any proposals considered, the record of decisions made, and how each member voted, and then adjourn, what time the meeting was ended. And so then there's a requirement that we have a draft of the minutes prepared and that we adopt them at the next meeting with a quorum present. There are exceptions, and those are the reasons that we can go into an executive session if needed. Not all of the 10 exceptions apply to the city of Santa Fe. There's one about gaming. There's some other ones that are not applicable to the city of Santa Fe, but the ones that most often come up for us are discussion of disposition of property, discussion of litigation that's either pending or threatened, discussion of personnel actions in relation to either the city manager, city clerk, or city attorney. And so if we're going into executive session, there's very specific requirements, and we've incorporated those into our procedural rules as well. basically we need to cite to the authority that allows us to go into executive session. And then when we return from executive session, we also have to have a motion that states the discussion was limited to those deliberations. The minutes are basically just a summary that the matters discussed were limited to those in the motion to close the meeting. So our procedural rules contemplate that an executive session may be listed on our agenda, but it does not have to be listed on the agenda. So we've had this situation, reconvene meetings happen a few times, which is if we need to stop a meeting and then restart at another time, we need to identify that time that we're going to continue the meeting in order to not have to restart essentially the process of posting a new agenda. I think we would often want to post the agenda again, but say we needed to reconvene the next day, those 72-hour notice requirements would not apply if we were able to, prior to recessing, specifying the date, time, and place of the continuation. So if we wanted to continue a meeting on a subsequent day because maybe we had a fire drill in a building or our Zoom connection went out, we would be able to do that. Although I'm not sure we'd have time to announce the date of a new meeting if we were having a fire drill at that time. But if something came up essentially that did not allow us to use a space, we could do something like this. And then if we did not post a new agenda with 72 hours, then we would only be discussing the matters that were on the original agenda at the future meeting. So remote attendance is something we are now very, very familiar with. Our ordinances did not permit for this for very long. We actually only implemented this, I think, about 6 months before the pandemic started. We included it in our emergency ordinance. So we have limited the ability of the city of Santa Fe to allow remote attendance at meetings during declared emergencies. We could be broader with that authority, but we would, it would still need to be difficult or impossible for a member to attend. So right now we've required there to be a declared emergency, and it's difficult and impossible to attend in person. We could have it outside declared emergencies, and if an individual had a difficult or impossible situation, we could allow for that person to attend. But our ordinances are a little more narrow on this subject than the Open Meetings Act. If a government has not provided a specific provision to allow for this, then they wouldn't be allowed to do this at all. So I think a lot of local governments, a lot of public bodies were scrambling to adopt this type of a rule to allow themselves to meet remotely during the pandemic. And this is the section that allows for it in city ordinance. This is specific to Santa Fe. During a declared emergency, members of committees may participate remotely at meetings by conference, telephone, or other similar communications equipment as permitted by the Open Meetings Act. So we didn't even know to list Zoom specifically at the time we adopted this. We had no idea that would be our platform of choice. So we do have guidance that has not been modified or rescinded since the beginning of the pandemic. For a while there this summer, we thought they might amend it, and then Delta happened. So this is why whenever we do go back to in-person, we're gonna have to refresh our memories as to what things no longer require roll calls, because the guidance essentially recommended roll calls for all votes. In our existing procedures prior to the pandemic, we did allow for votes by acclamation and voice votes of yay and nay on certain matters, mostly procedural matters like adoption of the agenda and that kind of thing. So we will be able to go back to that after the pandemic, and or when the Attorney General updates the recommendations, or if anyone thinks we're not needing to do these anymore. They're not binding, but they are recommendations, but we've been mostly trying to follow the recommendations at this point. We could come up with our own framework. But we do need to provide remote access for members of the public. We would suspend the meeting if we have technical difficulties, and we're trying to retain recordings of the videos.
I'm sorry, Erin, can I interrupt real fast?
Yeah, please.
Just want to clarify. I mean, we've had so many discussions about how long our meetings last on Zoom. Are you saying that there is the potential to remove roll call on everything, that this is a guidance and not a requirement?
It's guidance. I think we would have to be able to, we could look at it. So if there's an interest in that, we can look at it and see if there's a good way to make sure that what is happening can be conveyed through audio to the public adequately. So maybe if the chair was pretty specific about making a finding, like it sounds like the ayes have it, I think we could make a judgment call on that. We already required roll call votes on things like legislation, so that wouldn't change from our own procedural rules. But yes, it is guidance. I'm not aware of any enforcement actions around the guidance or them being interpreted as mandatory.
Okay. I mean, I'm not quite sure how much time it would save, maybe a couple minutes. So maybe it's not even worth it to like take the time to look into it, but just good to know. Thank you.
Right. I think that's a great question. And refreshing my memory on this is also helpful because now we've almost had this guidance in place for 2 years. So distinguishing between things that were guidance starting 2 years ago and what we actually did beforehand. And I'm not sure how clear it would be for the chair to know how if the ayes had it or not. We could experiment, I suppose. Zoom is kind of hard to talk all at once. Open Meetings Act requires substantial compliance, and that's important because we're human. These things we try. So if there's minor technical deviations, our position would be, as long as we are trying that, and as long as the purposes are being accomplished, I think our position would be that we're compliant. But certainly we try to meet the letter of the law, and usually we over comply, particularly in the city of Santa Fe, because we have many opportunities and ways for the public to access and attend our meetings and listen to our meetings. We don't just provide one means of attendance. We broadcast on radio, we broadcast on cable, or on Zoom, or on YouTube. So right now we're providing many forums that the public can access our meetings from, at least for governing body. And then for some of the other ones, there's at least a couple ways, usually phone and Zoom. So we have had complaints to the AG's office before. Mostly they just send an inquiry and ask us to respond to a citizen's complaints. I have not seen a complaint for the city of Santa Fe get beyond that. There have been other situations where Open Meetings Act has been used to invalidate a decision by a governing body in local government. So say a contract was voted on in a meeting that was not properly noticed, and that contract can be invalidated until it is voted on again. And then if there was a intentional violation, you could potentially get a criminal penalty for that violation. So that would be a situation perhaps where 5 members of the governing body decide to meet regardless and decide about something outside the confines of a public meeting. Are there any questions on Open Meetings Act while we're kind of transition to IPRA? I know the new counselors already participated in bodies that were required to follow the Open Meetings Act, so that's helpful for both of you, I would guess, having already been on the Planning Commission. Okay, if not, then I will start on IPRA real quick, and we'll try to go through IPRA relatively quickly. I think just a few things are worth reminding folks. So as most of you know, IPRA creates a procedure and enforcement mechanism to ensure that people can gain access to public records. And the public policy reasons that are identified in the state statute is that providing information is essential to a representative government, and that it's people have the right to know about the routine duties of public officers and employees. It's also good to refresh our memories about what records are considered public. It's most everything we create unless it has a specific exclusion, very similar to the exceptions to the Open Meetings Act. There's enumerated exclusions, a lot of which do not apply in most cases. There are certain police records, if something's still under investigation, that could be protected. Attorney-client records are one of the most common types of records that we would exclude from an inspection of public records request. Certain personnel records, but not all. So like hiring documents are not protected, that kind of thing. Whereas disciplinary records are protected. And certainly there's a lot of, we could go into super depth about that area of law, but I will probably not go into the details of it here, but there's some litigation on that issue right now that's pending at the Court of Appeals as to what the scope is of that personnel record protection is. It is important to remember the email, text messages, and also going back to social media. Social media could be subject to public records requests if it is relevant to public business. So you do probably want to keep track of where you discuss public business. An example I have is that I was on the redistricting commission back in 2015. So the clerk's office had my personal email for that purpose. Now and then, it hasn't happened so often now, I get a random email. And so obviously not Christine because she wasn't here that year, but when Yolanda was here, I would now and then get an email on my personal email. I would forward it to my professional email and just make sure I had it there and would respond from there. And that's what I would recommend if any of the counselors are getting business emails in your personal account, you can forward it to your business account. That way, for the purposes of IPRA, we don't have to ask you to search your personal account. It also is helpful with litigation, so we don't have to do discovery of your personal account. So ideally, keep all your business stuff on one set of accounts and hardware, if possible. And it makes it easier for us to comply with this and other laws as well, with IPRA and other laws. So we have currently essentially 2 records custodians, one who's assigned to the police and one who's doing everything else. And now we're going to have an IPRA manager because the counselor did approve the funding for that position. And so we will have essentially 3 records custodians working together. And they are the ones who coordinate all of our responses. And they receive requests, they respond, and they also can provide reasonable access. Mostly we're trying to provide it online now through our Next Request software, which if you haven't checked it out, it's pretty impressive. We have over 6,000 requests from the last year that are posted. You can look at, see what people are requesting. We primarily get written requests. Oral requests are permissible, but they're just not enforceable. So there's no way to enforce in court a oral request. And so they're supposed to provide the name, address, and phone number of the person making the request. And we have to get back to the requester within 3 days, even if it's just to tell the requester it's going to take us longer than 3 days. So that's called the 3-day letter. So we always send, well, if we don't send a 3-day letter, it's a problem. We try to always send one, and it's very rare that we do not get one out. Then we have the obligation of responding within 15 days with a complete response, unless the request is excessively burdensome or broad. But then that just means that we get to take longer than 15 days. It does not mean that we don't have to answer the request. So I think now and then people think if something's excessively burdensome or broad, we get to say, no, we're not going to fulfill your request, but we just get to provide it within a reasonable period of time. So most of the requests that will come for your information right now, Cindy Whiting is coordinating those, and she will contact if she needs responsive records. I think as we work through kind of the overload of requests, we're trying to come up with better strategies to work better with all the constituents. So certainly if you have feedback for Cindy, please feel free to let her know, let me know how to make it easier to help provide records. If there are redactions that are needed, those need to happen after we collect the records. We certainly appreciate folks giving us a heads up that there are, that there are matters of concern that are included in a request. For example, Aaron, I know that there is attorney-client privileged information in these records that are responsive. Just want to flag those for you. Definitely appreciate that. Cindy will appreciate that. I try to flag some for her when I know that there might be something to make sure that that we get a review of those before they go out. So we still have the obligation to collect the records, even if we're not going to provide them. We need to have a record of what we did and what we did not provide. So that helps later if we get challenged, we're able to show how we sorted out certain records and what our justification was. If we don't meet the 15-day deadline, we can have up to $100 a day in damages paid by the city. Thankfully, the city has not had large damages IPRA claims. We've had a few small ones, and it's mostly been issues where we were not able to find certain, or we didn't know about certain records, I think that's been the primary issue. We have one situation right now where the city may not have given a reason for withholding certain records. So those are the types of issues that end up in court being litigated. Also, I mentioned earlier, there's disagreements about the breadth of some of the protections on records. And so those are the reasons that we end up having to spend a lot more time on an IPRA than we would otherwise, as if that type of thing gets challenged as to whether or not we had the right to redact something or withhold something. Most of the time we are providing everything that's requested. It's just a matter of getting it together. There have been situations in other towns where very large fines have been applied. There's an example in this next slide, but if we are inappropriate in a denial, we can get its damages, also the costs and attorney's fees for the person who brings a lawsuit. So attorneys are happy to bring a case that looks good to them because they will be paid if the city did violate. So we are definitely trying not to violate. Some things that often come up with us and might come up with you, that if a record is requested that does not exist, we do not have an obligation to create it. There might be times where we decide we want to create a record that is requested. That might be in a media context or something like that. But then we can let the requester know this record does not exist. However, X department, X counselor is interested in providing you this information or this idea, this report, but they're going to do it outside of IPRA because that would not be subject to IPRA. And also sometimes we get requests to change the format of a document to something different, particularly say like a recording or a video, that kind of thing. Oops. We don't have the obligation to do that. Sometimes we do try if we're able to. Sometimes we're not able to. And I think we're mostly providing things in pretty straightforward formats. Or we can provide the opportunity for someone to come in and either listen or if it's an audio, or to observe if it's a physical record that is on a hard copy, or we can put it on a hard copy. We are doing less of that right now during the pandemic, and the AG's office gave guidance to not feel compelled to do that. So what we've been trying to do is change the format to what someone can still see or listen to, if at all possible. There is an example of this JAL case that had to pay over $400,000 to a weekly newspaper because they just withheld public documents, and that's a huge part. That JAL is a very small town, so you can just see the impact that a finding on a NIPR could have on a town, and an attorney's reasonable fees have been found up to $400 per hour, so that's pretty high. So I will pause here. Any IPRA questions? Nope. It's not our favorite area, but it's important.
I have one. I have one question for the record, if I may, because I think it's important for people to get a feel for just what this amounts to. Yep. I remember a briefing not too long ago about the increase in IPRA requests that we've gotten. Maybe I missed it in this slide deck, but it's been a geometric increase in outside requests for IPRA performance, and it's taking a huge toll on staff time. I don't know if you have at your fingertips the data, but for the whole governing body to know just what this amounts to when outside folks are really filing IPRA requests at a pretty rapid clip, it's a major staff time eater.
It absolutely is. Yes. I had, when we had all the paralegals available, I had several assigned to help out. We have a temp right now helping out until we get the manager on board, which has been extremely helpful to go through all the email requests. But yes, we have over 6,000 a year right now, which is incredible. When I was at Department of Health at the state, we had fewer than 1,000 a year, and that's the largest state agency in New Mexico. There's over 3,000 employees at Department of Health.
Any
Environment
idea?
had some more, they were a little over 1,000. So, and I'm guessing corrections and state public safety probably has more as well, because we did a substantial portion are public safety related. Police reports, dash cam, body cam. And I think as those, from what I understand from other jurisdictions, including Albuquerque, as transparency increases and availability of records, it increases the requests. Actually, we were hoping that people, because one of the advantages of the software we're using is that you can look at requests filed by other people and easily access the records that were provided to other people. So we thought, oh, this might reduce duplicates, that kind of thing. I'm not sure that we're really seeing that. I don't know that we're getting duplicate requests so much, but I think people are maybe more just inspired to ask for more stuff. So we have definitely increased access to records at the city in the last 2 years. We started the Next Request software, which allows us to easily track the numbers on an instantaneous basis. We're going to work on doing better categorization as we bring this manager position on board, and being able to target like which documents are being requested the most around the city, and are there ways we can make them available just automatically, right? So I think this will be a way to create almost a strategic plan as to which priorities we can have for making records more accessible automatically. And I know, like for example, the city clerk has now started posting all the contracts as they get signed. So that's like, and one of the advantages of this software is that someone can type in a keyword and we can have pop-up language, and we do have pop-up language that says, oh, you're looking for a contract? Let us redirect you to the site that has all the contracts. And so we do that also with records. I'm going to plug in my computer that are commonly requested from the city that are actually not available from us. So say like birth records or death records, we are able to redirect folks to the Bureau of Department of Health that has all those records that we don't maintain here at the city. So that also is a help to the public, and it hopefully saves some time that we're able to alert them that the city is not the custodian of that particular record and who is. And so as we get this volume, we're able to analyze the data more and help to redirect people, but it's not causing the number of IPRAs to decrease by any means. Yeah. So we are, yeah, so the Councilor Orientation.
Just to understand what you said, did you say the volume of IPRA requests in other jurisdictions have increased the same amount that ours has?
I don't know about the same amount, but I think Albuquerque has mentioned that as they've put more online, their numbers are not flattening. So I don't know about as much as, but because I don't know the rate of increase for other folks. Ours essentially has tripled since I've been here, but it may have been partially it might have been a documentation issue, but it's certainly more work than two people can take care of. So some of them may have gone undocumented before we had the system, but I don't think that many. It's been a huge increase.
Okay, thank you.
City Clerk Mahalsey.
Yeah, well, two things. One, I was just going to also note that you're right as far as documentation purposes go. We actually centralized IPRA into legal, where PD used to work kind of in silo in PD. And in an effort to create more public information capacity, we actually stumbled across this new area and were able to kind of give Greg full time to IPRAs, but I do think you're right. Now we're able to document and see the increase in the trends. I also was just going to give you a plug, Aaron, to say that the city of Albuquerque, they receive a similar number, even though they're obviously much larger. And
Is it similar to 6,000?
yeah, I think they get like 8,000.
Oh, geez. Yeah, I knew it was higher, but that's not much higher, actually, it turns out. But they do have a significant number of people assigned to IPRA, like a whole team. I think there's 8 people doing police records. So it's very high. And I look forward to being able to do a more comprehensive analysis of what we're providing for police records and how well we're doing in terms of just ensuring the right privacy rights and that kind of thing, and ensuring the completenesses of requests. I just think that for one person, it's just been way too much.
How many requests does the county get? Anybody have a clue?
We could find out pretty quickly, but I don't know. Yeah, I don't know off the top of my head. Yeah.
When
And
I was, sorry, Mayor.
Do we have frequent flyers in IPRA land the way we have with constituent services?
To some degree, yes, but not to like the hundreds type of level. But certainly certain reporters do consistent requests, which is not surprising. So like, a reporter on a criminal beat is asking for a lot of criminal records, not surprising at all. But yeah, our reporters frequently file IPRAs. We have certain attorneys who have liability cases against the city, like tort claims that might represent a lot of people in crash cases. They might not be for the purpose of suing the city, but it might just be for the purpose of building their case against whoever their defendant is in their crash on the city streets. So I'd say yes, personal injury attorneys absolutely are folks, but I don't think that's that's not an abuse of the system. That's pretty straightforward and not surprising.
Thank you.
I guess, yeah, and maybe prior times they might have gotten those through discovery, but it's become pretty common practice to request that type of documentation earlier in the process before a lawsuit's even filed. Yeah. Okay. I think it's quick break time if that works for folks. I don't know how many minutes we're going to take. Do we have a preset time?
We did. So we were scheduled to go on break from 2:45 to 3. If that still works for everybody, we're about 5 minutes early, but I'm sure a quick 20-minute break would be welcome. Unless you guys want to start back at 2:55 instead of 3.
One's fine.
I think 3 is fine. So we will see everybody back at 3. Thank you.
Great, thank you.
Mayor, I think everyone is back. So I don't know if we want to move into the second half of the presentation. Erin, I think Jesse is probably going to jump on for this portion with his presentation. This is both the annual Parliamentarian Procedural overview, and then we'll go over the procedural rule update, rules update, and then a bit about the legislative process. So
yep. So I'm prepared to kick us off on the second part. I think my part will be a little bit shorter. And I think we're hoping to not take the full afternoon. So as wild and crazy as that sounds, although we did think the first half would be a little shorter than it was as well. So we'll see how it goes. But again, feel free to interrupt me. I will be sending out some materials that we're discussing here, and then maybe some more as well, depending on what folks think will be helpful. So we are going to start with our annual parliamentary procedure update and training. And then obviously this year, we have the special privilege of having all new procedural rules at the governing body level that we just adopted recently. So those are one of our parliamentary rules, our procedural rules. So I'm going to be sharing my screen again. And really parliamentary procedure is everything that is included in how a body conducts its business and makes decisions, essentially. So not just legislative bodies, but also other organizations that might have a board that makes decisions with a group of people. So parliamentary law includes Robert's rules, the law of British Parliament, the procedural rules of the governing body, and the rules and precedents governing the proceedings of deliberative assemblies and other organizations. Our parliamentary law includes in the following precedents all of these sources. So we have to comply with the US and New Mexico constitutions in cases that interpret them. We have to look at state statutes when applicable. Some state statutes might not apply to the city, but Open Meetings Act is a really good example of a state statute that has a huge impact on how we run our business. Our city charter, and I put the city charter and state statutes both in blue because there could be times when our charter would be essentially overruled by a statute, and there could be other times where we put ourselves outside of a state statute construct and we're permitted to do so because we are a home rule municipality. So we might have to look at the specific provisions of a state statute and determine whether or not the intent of the state was to preempt our ability to do something in a charter. But that would be where there might be a close question. But then after that, we would look at our city ordinances regarding legislative procedures. And so Jesse's going to actually talk about a couple of those. Some things are set in ordinance, such as like what is a resolution, what is a bill. Those are not in our procedures. And then our procedure rules would be the next in order of hierarchy, then Robert's rules, because our procedural rules basically say if it's not covered here, go look at Robert's rules. And then custom, consistent with other applicable rules. And we'll talk a little bit about custom. We've used some customary procedures both historically and right now we're using one that I just want people to be aware of. It's fine, but it's just not contemplated in Robert's rules. So the examples of constitutional limitations on us are due process, the First Amendment, anti-donation, and I just wanted to flag for people that comes up now and then is the limitation on us to regulate firearms. So that's the type of thing where the state reaches out and says, city government and also county government, so local governments, we're going to prohibit you further than we're prohibiting ourselves to regulate firearms. Due process comes up primarily in quasi-judicial proceedings. For legislative matters, the due process that's required is just access to the representative government. We have created more access than is what the minimum that the constitutions would require, because we do provide for public hearings. And we do provide for ways to submit written comment on our agendas and things like that, which are probably more than what is the minimum required in the Constitution. First Amendment, the reason I listed this here is because it's just good to remember that once we create a forum, then we can't really, we have to be consistent and unbiased in terms of how we allow people to use that forum. So for example, we have the petitions from the floor. Once we've created that type of a forum, we can't say only people who like X, this park change, can speak from petitions from the floor. We can't regulate the content of their speech at that point. We can do it on topically, so we can say, if you've got something to say about a bill, here's the time that you have the opportunity to speak about that topic. So we can set a time, place, and manner restriction on speech, but we can't say we only want to hear, say, the people who are for this matter, but we don't want to hear from the people who are against this matter. That's making it extremely basic, but that's the general idea. So that comes up in public meetings as a constitutional issue that we have to look out for. Anti-donation clause, I just list this because it's one of the common issues that comes up in relation to, say, contracts, appropriations, that kind of thing that are often discussed during governing body meetings. So I'm kind of skipping between constitutional down to Robert's rules, because we already talked about open meetings, which is the statute. And then Jesse's going to be talking about our procedural rules and some of the ordinances. And then after that, the next thing in the precedence of a hierarchy of our parliamentary rules is Robert's rules. And so I wanted to pull up a couple of charts, which I'll also send out to everybody. And I think we sent out last year. Oh, we got a question. Mayor Weber.
Yeah, I think it's worth taking a minute to go back over how the anti-donation clause works and what it does and does not cover. It is a real tricky piece of business in my experience. We get requests from organizations to be their fiscal agents, or we're asked, can we support this good cause or that good cause? And I tend to refer all of my requests to you, City Attorney, but I do it without really a clear sense in my own mind about how the anti-donation clause actually works and what is or isn't inside the boundary.
Yeah, it's a huge topic. And I've actually heard there's some conversation at the state this year about potential amendments to the Constitution for the state of New Mexico related to the anti-donation clause. So it is at the state level that prohibition is there in the state constitution. And so meaning it's not also in the US Constitution. There are some other states who have had similar provisions and or still do. Some have modified them. We've modified ours a number of times in New Mexico to allow for certain things. So basically it says the government shall not lend its support to private enterprise, and that includes nonprofits, businesses, except for the following exceptions. So then it lists certain exceptions. It would be almost potentially worth a whole study session, not like a multi-hour study session, but maybe like a whole hour to itself to talk about some of the ins and outs of that topic. It is relevant to our procedural matters just in the sense of it kind of limits what can go on our agendas in certain contexts. And it's a question that comes up really often with some of our agenda items. It's the reason that we typically have to enter a contract with a private entity in order to get something in return for funds. If we're going to pay city funds, we usually need to get something in return that's adequate compensation. It's the reason that when we say lease our land, we generally do an appraisal to verify that we're getting adequate compensation, which has often been interpreted as like a market value for something. So the market value for land. Some of the exceptions are for the Local Economic Development Act. There's exceptions for certain scholarships. There's a carve out for the care and maintenance of indigent persons, which we certainly use frequently. Indigent is not defined in the Constitution, so it's been defined under varying degrees of specificity and flexibility in different places in the state. Those are some pretty broad brush characterizations. Marcus, is there anything that comes to mind to you where you say, Aaron, you're not mentioning something?
The only big one that is affordable housing.
Yes, affordable housing is another. Yeah. Yes, thank you. Yeah.
I'm not sure I'm up for a full-on study session, but I do think this is something that I know we typically, I have frequently run into we're just doing a good deed here. We're helping a well-meaning nonprofit by doing something. And then it turns out that it isn't permitted under what is, in my experience, unique to New Mexico. I'm not sure how many states have this in their constitution, but it does often create a consequential block to doing something that seems on the face of it a worthy activity, but is not allowed under our state constitution.
Definitely. And there are a few other states, I don't know a comprehensive list, but it came up in the West primarily because of corruption with the railroads. So there was government lending aid to private enterprise, particularly with the railroads. And so it was an attempt that started with that, but was not limited to that, to stop government from essentially giving the wealth of the people to private enterprise. A way that it's, if something that a private entity is doing is something that the government would like to do, and the government wants to create a program to do that, the government could create a program to do that type of activity. And then just depending on what it is, you might be procuring services through a mechanism that's permitted under the procurement code. So if there's something a private entity is trying to do that we think is a good government purpose, we could create a program around that goal, whatever it is. And going back to Marcos's earlier slide, that entity would not be able to create the criteria. The government would create the criteria for the program, and that type of entity could apply for funding. So that's one construct through which we can accomplish some of the same goals that might be desired in that type of a situation where the private entity is that's doing something fantastic for the community, and we agree with that goal. And that would be one way that we accomplish it. But I know there's other circumstances. It is very interesting. We could absolutely do a study session. I mean, I'm sure many people in this room don't know about certain things that we've had complaints about and what our justification has been that I think are entirely valid, but it would be quite a rabbit hole to go down right now. I did throw it in there to demonstrate the framework, really, right? So we have certain things we don't have much control over and other ones that we do. And then we can look into strategies that are sometimes achievable or sometimes allow achieving a goal, but it just might take more steps.
Thanks.
Councilwoman Villarreal, did you have something on that issue?
Yeah,
too?
just a question also to let you know that Councilor Garcia is waiting in the attending room. But I wanted to, maybe if you could elaborate why funding support, or I don't think they're considered donations, but money we give towards fiestas, any market, Spanish market, how those do not fall into the anti-donation arena?
Sure. I think the way that the city has considered certain events is to be city events. So if it is a city event, which we've essentially identified by adopting an ordinance identifying it as a city event, and then we have some sort of control over it as well. So if we're allowed to fund our own events. And so if we decide something is partially our own event, we can help fund it. I was not here at the origination of those decisions, so I can't tell you for sure what the chain of public policy to support the specific decisions. So I'd want to maybe research it more, but that is part of it, at least what I just described.
Okay, thank you.
And there may be more to the story as well. Yeah. So I was about to show a couple charts, which I'll also send out, and some of you may have seen these before, but I just wanted to give some idea of the type of analysis that Councilor Merrill-Worth and I have to look at in order to help advise the mayor on procedural issues with Robert's rules. And these are the charts that I find the most useful in the Robert's rules books, which the one I have in front of me, and I did just get the revised version, and I'm going to try to find out what the differences are with the newest version of Robert's Rules. But the penultimate version of Robert's Rules has over 700 pages. So we are obviously not going to go over all of that today. There is a training program online we found if people are interested that I found it to be at least somewhat helpful. And I'm planning to do some more through that program, and Councilor Marworth can speak as to whether or not she found it helpful. I think she did some of them as well. So if anyone's interested in that, particularly, I think I was talking to Councilor Cassetts, and she's now chairing a committee. She might be interested. If any of you who are chairing committees are interested, I can provide you the information about the one we found. There's a couple organizations in the US that provide training. These are online, which is nice. So I'm going to share, let's see. Okay, so this is called Chart 1. This is the first chart in the appendices of Robert's Rules. And I just wanted to show this to kind of just explain some ideas. So the motions listed on the left here are listed in order of what's considered precedence. You'll notice the main motion is on the bottom, and that's usually the first. You have to have a main motion on the floor generally to have a discussion. Then everything above the main motion has a higher precedence. That's why it says order of precedence of motions, which means that if you have a main motion and someone makes a motion to amend, that's the higher precedent motion. So we go to that one first and we address the motion to amend before we go back to the main motion. And so that example applies to all of this. You could possibly have a main motion, and then you could have a motion to amend indefinitely, and then you could have a motion to amend, and we would have to address first the motion to amend, then the motion to postpone, and then the main motion. And so that's the first, I think, thing to know about this chart. Then you see on the right-hand side here that some are debatable motions and some are not debatable. Some are subsidiary motions, which means they come up as a product of the main motion, so they relate to it. And then the privilege motions might have nothing to do with the main motion. And it's interesting, Councilor Villarreal, you actually made a great example of something that could be a privileged motion when you said, or question or motion. You could interrupt for what's called a raise a question of privilege to let us know that one of the counselors is stuck in the waiting room, for example. So, and the equivalent in a physical place would be someone's outside knocking on the door and they need to get in, or somehow some of the door got locked or something. It could be something about like the functioning of the meeting, that should have higher precedence over these other things. And other examples given in Robert's Rules are like the heating just went out, or some alarm is ringing, or that kind of thing. It could also be up here with question of privilege. It could be there's something misstated in the agenda that needs to be updated, that kind of thing, or the packet material is adhered to the wrong item, something like that, something that relates to the operations of the body. So I just thought this would be nice to have all in front of us. Are there any questions on this specifically that we, Councilor Villarreal?
Just the piece about raise a question of privilege, which we don't typically use that language. Is that also similar to point of clarification? Because I think we use that more often. So how is that different?
I think that is essentially a point of privilege. If it's really to make sure that the information, if it's used for making sure the information that everyone's seeing is the same, that type of thing, or that you're looking at the right document that's being referred to. Oh, my cat is joining us. But if it was something like someone's referring to page 3 and you're like, I have no idea what this person's talking about, right? Like that type of a thing, I think is that what you're meaning when you say a point of clarification?
Well, it comes up when we're trying to understand process, usually in meetings. And
okay, so that would be a point of order.
That's why I'm confused
usually
about point of order versus point of clarification. Yeah. So you're saying point of order is process?
Point of order would be if you think someone's not following the right process and you're trying to get us back on track. And I do think that falls under basically the question of privilege as well. It does have higher precedence than most of the other pending motions or pending issues. Councilor Merworth, do you have anything on that point? The point of clarification, I'm not, that might be kind of a custom that we've been doing. I'm
Yeah, I
not
feel-
totally clear.
I feel like it's grown into kind of a custom. It's like what we tried to get away from last year when we would say on that point. And we have been working really hard not to say that anymore. And so sometimes a point of clarification, I feel like, gets used in a substantive way rather than a procedural way, where really it probably should be a point of order.
So if it's something that is out of order, right? Like if it's something
Yeah.
we think is out of order, that should be a point of order to clarify where we are perhaps as well. Like, are we like point of order? Are we on the amendment to the motion or the motion, right? Like that would be a reason to
Or-
interrupt.
Yeah, or point of order, we don't have a main motion.
Right.
Or
Right. So there, in terms of the clarification, I think we might be crossing a few categories of motions, and one might be like there's a motion for request for information as well. It might just be like, oh wait, I can't vote on this because I need whatever fact, or I missed that data point or something. So we might want to look at refining that use. And so I can do a little bit more research, maybe also with Councilor Merworth, and make sure we're on the same page as to when it's right, or if there's better ways for us to state it.
That would
yeah,
be-
and one other place where I know, and I can't remember what I say, but I know at the beginning when we do at the beginning of a quasi judicial process, and I ask the city attorney's office to explain that process and what our role is. I know sometimes that happens automatically, and sometimes I jump in to get it to happen, and I can't remember what I say, whether I say point of order or point of clarification, or it's not really a point of personal privilege. It's more, hey, wait a minute, we should do this first. So yeah, we should look at that a little bit.
Aaron, can you pull up the chart again?
Yes, I can. And then I wanted to show one other chart too, just for demonstrative purposes mostly. Oh, I pulled it up, but now I will share it too. Here we go. Is there a specific, oh, you're on mute, Councilor, are you?
No, that was just me reading to myself. I wasn't
Oh,
actually
okay.
saying anything.
Thought I
I'm
saw
one
your
of
mouse
those people
moving.
that likes
Okay,
to
got it.
move my lips
Okay.
when I read.
Got it. Okay. Is there something on here that caught your eye?
No, I just, as we were having the conversation, it was just helpful for me to have that visual. So thank you.
Yeah, definitely. And then you'll notice, so on one of the ones that I think I'm gonna highlight is calling the previous question, which is right here below, lay on the table. You'll notice how the arrows go out because it means it goes back to what might have been the prior question. So it's like this could relate to first, if the limit, so it would go back to the first one that the arrows go back to, and then subsequently down, cascading down. Thankfully, we don't have that type of a situation come up very often. We did successfully amend an amendment at the last meeting. I don't know if people noticed that, which I think may have been the first time we've had that happen. So did you want me to keep it up still? I think.
No, I'm okay on the chart, but I actually do have one question that's come up. I know that in general, as long as we follow Robert's rules, unless we have other rules in place that are stated. So do we have anything in our rules that would ever disallow any of those motions? Have we ever said, I mean, I've noticed like on there that there's this place where you can limit debate or not limit debate or extend the time of debate. And we currently don't do that, but there's nothing
Yeah.
saying that we couldn't.
Correct.
Just as
I
an
think that's right. For at least in governing body, yes, absolutely. And then I think we've added some specificity on the committees in terms of referrals and things like that, which might limit a little bit on what is permissible. And then I would say there's a few places in our procedural rules, like there was the question of whether or not we needed to like lay the matter on the table in order to suspend the rules. We did not need to do so because our own rules said that we could suspend our rules at any time. And it's expressly stated in our rules. And I believe it still says that in our new rules. So that's a place where we've overridden Robert's rules that says you don't have that type of a conversation without laying the matter on the table. Although we probably could have made it into something that would be privileged, but or higher priority. There's another chart I just want to show that just to show an example of the type of helpful chart that's at the end of Robert's rules, and we'll share some of those as well. And this is just another way to help a quick reference chart. So as to actually, I'm going to show a different one. This is the first one. I think I have 2 pages here. Yeah, so this is the first page of many pages that basically classifies each of the motions into categories and says whether or not you need a majority or 2/3, and whether or not it can be reconsidered and under what circumstances. This is mostly to illustrate, like, this is how we would figure out whether or not we could take a vote on a certain matter. And then the class of motions on the left refers to main as an M. P is privileged, I is incidental. There's no I's here. So all those relationships determine what happens next. Thankfully, we don't get too far into the weeds generally on this stuff. But it's possible. So any questions on that one, Councilor Garcia?
No, I think I understand all of that pretty well. I did want to go back and maybe ask the question. I know this was brought up in one of our quality of life meeting. I think there was the first one that we had, and there was a question and answer back and forth, or called as to at what point do we have discussion? And there was an agenda item, and I believe the chair asked for a motion in order to discuss. And so what is the rule? And if the rule is the rule, then we should all follow it from governing body, I believe, all the way down to committee. Would that be correct to say?
Councilor, thank you for the question. So I think there is a practice, or there has been in some committees, to start discussion before motions on the table. Robert's rules does say to put a motion on the table before discussion starts. One of the next things we're going to talk about is custom. So basically, if there's not a point of order called and there's a manner of doing business that's working, people are being able to participate. Robert's rules does recognize that customary practices are fine until they're not fine and someone calls a point of order. And that was happening, I think, for certain things in this context of governing body, but also in relation to, I think, the friendly amendment situation. And that was, someone asked me about that. Friendly amendments are actually not recognized. Yes, Councilor Lindell. But there was absolutely a custom, and I've seen in historic meeting minutes for the governing body that friendly amendments were being used, which means someone makes a motion, it's been seconded, and someone else says, Councilor Garcia, would you take it as friendly to amend your motion to say 6 instead of 8 or whatever, dollars for that expenditure? And you'd say, I take that as friendly, and then your motion would be amended at that point. But that isn't contemplated in Robert's rules. Robert's rules does contemplate a formal motion to amend the main motion and a vote on it. We have now adopted a new custom, which is also not contemplated in Robert's rules, which is to allow the motion maker and the seconder to withdraw their motion and their second in order to make a new motion. Robert's rules actually says that we should have a vote, and that the motion maker and the seconder actually have no more power than any other member of the governing body. So do we have to change that? As soon as someone calls a point of order, essentially, yes. But it's been our custom and it hasn't seemed to cause a problem. So it doesn't, we don't have to change it. Is it consistent with Robert's rules? No. Robert's rules is not always the most efficient way of making decisions. So I think
Right.
we can recognize that.
I guess I would just maybe say again, to keep things somewhat consistent, is to try, for all of us to say this is how we're doing it, not just change it at any given time. But I can see how sometimes that does happen, but leave it up to the chair that's basically in charge of the meeting. So thanks again.
Yeah, no, I appreciate the question. It's very much timely, I think, because I'm gonna go back to a couple slides, and then I think I'm turning it over to Jesse. So I actually had this exact next slide intended to be here. So after the formal rules of Robert's rules, the next, oops, no, hold on. I want to start from the beginning. One second. Okay. Okay, so yes, I did have these two examples of customs, one that we previously had and one that we are currently using. So certainly Robert's rules are a higher priority, but we have not on these two. On the second item, we've been following the custom. So for government purposes in New Mexico, and this is because of the Open Meetings Act, generally substantive main motions will be on the agenda. Otherwise, we're not really allowed to have the conversation. So generally we have a main motion, which is whatever the matter is on the agenda, or it's procedural or non-substantive. And main motions are made when there's not another matter pending. So that was what we were talking about on that chart where it starts at the bottom. So nothing else is pending. That means the next motion is going to be a main motion. And then we talked a little bit about amending the main motion. Basically, anytime we have a motion pending and we want to change that, whatever change we're making is an amendment to the main motion. So that's when counselor moves to approve a resolution, get a second from another counselor. We provide the first counselor the opportunity to speak on behalf of the main motion. And then another counselor can make a motion to amend the main motion as follows. If I move to amend the resolution to include amendment 1 proposed by Counselor D or by that counselor themselves. And once that motion receives a second, we would then have debate on the amendment to the main motion before we return to the main motion. And this is, I think, kind of our most common procedural action lately. There's been a lot of this. So then we would have debate and vote on each of the amendments to a main motion, and there can be amendments to the amendment. And as we saw on that chart, the motion to amend is considered subsidiary, meaning it's secondary to the main motion, and it also is attached to, so it only relates to that particular motion. Something else I think that we have seen relatively frequently that's good to be familiar with is calling the question or moving the previous question. And that allows debate to end on a matter without further debate. And with our body, it's appropriate to make that motion once everyone's had at least one opportunity to speak who wanted to speak. Not everyone has to have spoken. And then there's no debate about closing the vote. It requires a 2/3 vote. and then debate is over, and then a vote. If that motion passes, if the motion to call the previous question or move the previous question is adopted by a 2/3 majority, then there's an immediate vote on whatever the preceding motion was, whether it's a main motion or an amendment. So it could be the amendment or it could be the main motion, just depending on what was pending at the time the calling the previous question was made. So that's what this is about. So I think I was going to just stop there and let us go into our discussion of updated procedural rules and legislative process, unless folks have other questions. I think got at least one follow-up for helping on point of clarification and what type of a motion would call for maybe just more information from a staff member type of thing, the circumstance that Councilor Merowith described. Any other follow-ups for people that would be helpful before we go to Jesse?
So, Aaron, back to do you have to have a motion on the table prior to discussion? So at the governing body, we do put a motion on the table before we start discussion. At the committee levels, it has not been our practice to do that. And I think, and I don't know whether this is the right time, but I think we need some guidance, or we need maybe to have a discussion about the pros and cons of that and why maybe at the committee level we don't do that. And because otherwise I fear we're going to descend into chaos.
Okay. So I guess if any, so you absolutely can, I think as chairs require that, or if anyone calls a point of order, I think you're required to do it. So you could just do it if you want to, because our committee rules do say that we follow Robert's rules. If it's working better a different way, we could amend our rules, or if the custom is just working and no one's challenging it, then you could also continue until you get an objection.
So where are our committee rules?
Councilor, however, we'll send out the resolution to make sure everyone has it. There's a resolution that adopted committee rules, which is older than our one adopting the governing body rules. So we'll make sure everyone gets a copy of that. I think it's if maybe Jesse can clarify if it's in the handbook or not. Did we include that in the prior version?
You mean on the governing body procedure rules? I don't think we've sent out the committee rules. We do have it. It's probably got to be at least 15 or 20 years old. So it has not been amended or updated in a long time. So that is next on our list of priorities.
Yeah. So we'll make sure everyone gets a copy of that.
Do we use it?
Yes, because that is what requires Open Meetings Act to be adhered to.
Okay.
Yep.
I mean, it sounds like it might be a discussion for, oh, I'm sorry. I forgot that we're in like a real meeting.
Yeah, so Councilor Villarreal I think she's next. Yeah.
Thank you. I guess what is different about the committee process versus like what we're voting on in governing body is that we're seeing things for the first time, and then items that are on our consent are transactional in nature. They're not necessarily resolutions that governing body members are pushing through. It's in most cases like staff contract approvals and budget adjustments. So in my mind, that is something we are seeing for the first time. So how would we be able to make a motion when we are in the process through committee for a discussion on something that we decided as the person that pulled it off the agenda? And therefore, we should have that time to be able to ask our questions and anyone else and then make the motion. So to me, it's backwards. Like, it doesn't make sense to me to make a motion on something that we haven't even had a discussion on that's transactional in nature. So it's not legislative. So that's why I feel like it's a little bit different and it's varied. And so committee process is slightly different than what we are practicing at the governing body level.
Mayor Weber, Councilor, we absolutely could distinguish. We just haven't. There's just nothing in the rules right now that do. My understanding, and I don't know where this practice comes from because it's not in the rules for the committees at all. So we do have discretion on it. Is there's no requirement for a consent agenda on committee meetings, and there's no requirement that everything goes on consent for committee meetings. My understanding that's just been a practice too. So it might be a good practice. It might not make sense for everything, but my understanding is both legislative matters and transactional matters, at least in some committees, have been all put in consent. And so it's only things taken off consent that are separately discussed in terms of a practice. That does not have to be the practice. That is not currently required under our committee rules. So there is flexibility on that point. I'm just letting you know what the committee rules say about procedures. It just doesn't distinguish between those two types of matters. It doesn't distinguish as to what should or shouldn't follow Robert's rules.
Okay. And I guess what has also changed over the years since I've been on council is that not everything has been on consent. Now everything's on consent for committee at the committee level. So that's why that shifts as well. So just to be cognizant of that change, that wasn't the customary practice, but I guess maybe it would help to define that from the committee, like consistency for committees. I'm not sure. But that's like a whole nother process that you're saying that will have to happen, correct? Like in updating procedures, the committee,
Yes.
the committee
Right.
procedures are separate.
They are, yeah. To some extent, there was a few things added in the governing body procedural rules that related to how legislation would move through committees before getting to governing body. But beyond that, yeah, how individual agendas or committees are run is in a totally separate resolution and set of rules.
Okay, thank you.
I think Councilor Cassett.
Yeah, thank you. I was just about to say pretty much, that piece is that when we found with updating the governing body procedural rules, there were a lot of things that led into other things. And so this probably is not a conversation that can happen isolated today or a decision, but it sounds like something that as we are really looking at those committee procedural rules that we'll have to jump into. So that was going to be my vote, was to move along and realize that this will be a larger conversation to take up at another time as we look at the overall committee. Thanks.
I just add that I appreciate that. And I just wanted to flag the fact that I don't think we have a decision. And so as we hold committee meetings, the process may be different depending on who makes up the committee and what the will of the committee is. So we'll see. But obviously a place we need to have some more conversation.
I think it's really helpful conversation and really helpful to have us bridge into that discussion as we move forward. If we are going to be amending those rules, I think it's a great prelude. So I think Jesse's ready to jump in. Is that right, Jesse? Okay, I'll turn it over to him. Thanks everybody for your questions. Really helpful.
And everyone see and hear me, or at least see the presentation. Okay, so we're just gonna, I shouldn't take very long on this. And as with the other presentations, if you have any questions, as I'm going through this, please just, I don't know that I can see all of your raised hands. So if I don't notice you, please just say something if you have any questions. In this, it's only about 11 slides. I've incorporated some of the changes that we've made to the procedural rules recently in what I'm discussing. If there are any specific questions that we haven't already talked about either with Aaron or after we go through this about the procedural rules, we can certainly open a discussion on that afterwards. So how resolutions, bills, and contracts are requested, introduced, moved through the committee process and adopted. So first we'll start with what is a resolution. So this is defined in code section 2-2.2. It's not a law, so it doesn't govern the city or the residents of the city, but it's rather a statement of support or opposition. So we have a few examples here. So there are resolutions supporting legislation at the state level, removing the tax on Social Security, supporting certain food policy, paid medical leave, things like that. Two examples, one of which we'll be discussing on Wednesday. Additional examples are the banners, in this case, the veteran banners. We've also had banners for celebrating Lafonda's 100th anniversary, as well as banners along Guadalupe Street for that district. Also, the sale and consumption of alcohol on city property, if that's requested by an organization, that is approved by the governing body via resolution, and that's stated in code in section 23. General plan amendments are done by resolution, and then various policies. So for example, the 40-year water policy was done by resolution, and then we adopt the budget by resolution as well. So then what is a bill? A bill is a proposed change or addition to city code, or other such legislation that requires a public hearing. So a lot of land use cases are bills but don't get codified into the Santa Fe City Code. Once a bill is adopted, it becomes an ordinance. So there are three terms that you will regularly hear. There's resolution, and then there's bill and ordinance. So that it's different from Congress and state legislature, where a bill is a bill is a bill. Here, a bill is a bill until it's adopted, and then it becomes an ordinance. So a little distinction there. So bill changes city code, so changes to election campaign or public finance codes in chapter 9, any franchise agreements, rezonings, land use rezonings, approval of bonds, and changes to city structure. For example, the reorg that we did a couple of years ago was done by a bill that became an ordinance. And something like a bond or a rezoning those are not codified in city code. Just a note on the bills and resolutions. Right now, the bills, resolutions, and ordinances can all be found, once they're adopted, can all be found on the city clerk's webpage. They have digital files going back to 2006, 2007, and then there are microfiche files going back even further than that. We are looking at putting those up on Unicode as well, to sort of keep them in the same location as city code, but right now they are available online on the city clerk's webpage. So then you will hear the term FIR, or fiscal impact report. Similarly, at the state level, all legislation, whether there is a fiscal impact or not, requires this document. And so the staff associated with the legislation, the person who speaks about it at the committee level or a governing body, is the one who is responsible for filling it out and verifying that the information is accurate. The FIR will be reviewed and signed by the city attorney and the finance director prior to it being heard at committee. So they're going to look through and make sure that for the city attorney, make sure that the description is accurate, and for the finance director, make sure that the financial information is accurate, that the funds are available, and that the projections are correct. And so it provides not only the opportunity to explain fiscal implications, but also what the legislation attempts to achieve, consequences, benefits, and some other information. And so for those of you counselors who have been here for at least 2 years, you may recognize the document on the right. We are going to go back to doing this because we have moved away from that, which is mostly my fault for not ensuring that all requests are, all legislative requests are not done through this document. So how is legislation requested? I'll be sending out this form again. And right now it is a fillable PDF. We are working to do it as an online form, so you can input all the information and it will dump it into a document that will automatically be sent to Jeff and I. So I think that will be a little easier to fill out and more accessible. But I will let you know when that is available. It shouldn't be too long from now. So we just want to make sure that we are accurately tracking your requests. We know that the date that they are received, so we can, make sure that we're creating some sort of priority list based on when the requests were received and any other information. And so those will go to the Legislative Services Office, which right now is Jeff and I. How was legislation introduced? This is a slight change based on the new procedural rules. So at the time of legislation, it must be fully drafted, reviewed, and signed by the city attorney. So that requires both members of the governing body and staff, if they have requests, to get those in earlier, if they have a specific date that they'd like it introduced. That way, Jeff and I and Aaron have time to draft, review, and have signed all the documents necessary to get it introduced. And then we have a new section you'll see on tomorrow for introduction of legislation that comes after communications from the governing body. This gives the primary sponsor 3 minutes, up to 3 minutes, to introduce and offer an explanation of the legislation if they so choose. Any co-sponsors listed at the time may also give up to 1 minute for the same purpose. And then anyone else who wishes to co-sponsor the legislation at that time, this is the time to do so. And also recently adopted is you can still add yourself on as a co-sponsor up to 72 hours before it's scheduled for adoption. And just to clarify, you don't need to be a co-sponsor in order to vote for something. You can vote for it without being a co-sponsor. There are no questions, discussion, or debate during introduction, and there's no public input at this time either.
Hey, Jesse, can I ask a quick question about adding yourself as a co-sponsor that came up recently in a conversation with Jeff?
Yes.
You're Jesse. So what is the best process for you guys for us to add ourselves as a co-sponsor? I know sometimes we say it publicly in meetings and this gets missed. Do you then need us to email you afterwards? Because I noticed on our governing body agenda for tomorrow, we have a number of resolutions where the captions don't list all the people that I know had signed on to be co-sponsors, and what the caption says and what's actually on the draft of the bill are different. So understanding what's best for you guys to be able to capture all that information, I think would be helpful for us and hopefully for you as well.
Thank you, Councilor Casa. Good question. I appreciate that. So I know that some people will mention it during a meeting. If it's during a Monday meeting, I don't go to those. So, Jeff may miss it. He may not write it down. Staff may, if Jeff missed it, the liaison may hear it, but not know that, maybe she needs to email Jeff and I and make sure we got it. If it's during a governing body meeting, maybe they'll, again, verbally say it, or maybe you email Christine or tell her, and then I don't know if Christine, is really busy and doesn't get it to me. So the best way is to email Jeff and I and just make sure. I know I was out last week and I'm semi out this week, so I apologize if there were some that were missed for this upcoming meeting.
And I would like us, this is Aaron, I'd like us to create a easy way to declare co-sponsorship that doesn't involve a variety of options for steps. Like, I'm not sure what that is yet. If there's suggestions on that, I think it would be great. Because it coming from all different communication sources to all different people is definitely not serving us well for the counselors or for staff. So we're working towards some sort of flow.
But for the moment, what I just heard Jesse say is that essentially, if we want to co-sponsor, we're welcome to say it publicly because we do things like that. But we also should email Jesse and Jeff to make sure that it's for, and until there's a different flow. Am I understanding that correctly?
Be my request at this time. Yes, thank you.
Okay. Thank you.
Absolutely support that. I'm just welcoming additional suggestions. If anyone has a good idea, we welcome it.
Councilor Romero Worth.
Thank you. I would also just suggest that, emailing after something is introduced may be fine. But if you're going to add yourself as a sponsor, co-sponsor, within the 72 hours ahead of the final governing body meeting, it seems like you need to think about the process of how you're going to ensure that counselors who want that are reflected on the agendas. So I think, it's been brought up that the sponsorships, the agendas don't match, and I don't know. I mean, maybe it doesn't matter, but just something else to think about.
Thank you. It can be difficult to track all of them, but certainly having an email, a digital, physical in a certain sense, copy of it as opposed to audio is very helpful. So when people add themselves on during a governing body at the introduction, I think for the most part we get all of those because we do have a meeting the day after to go through all of the adopted legislation, as well as people who added themselves on as co-sponsors. So I think for the most part we get those. It's more at the committee level that sometimes they get missed. Okay, moving on to resolutions. So with the changes that we made recently to the procedural rules, there's the way items move through the committee process is a little different than we did previously. So we have the first step is the introduction that we just discussed. It'll go to a subject matter committee. So that is an advisory committee. So public safety, BPAC, park, things like committees like that. It's an optional step if it directly relates to their work as an advisory committee. Then it goes to the first city committee. It could be referred to just one committee. It can be referred to all three. Just depends on the relevancy of the various committees to the item. And then in discussion with the sponsor, we'll determine which committees it goes to. So if it's approved at the first committee, it will go on to the next committee or governing body, and that would be on consent. If it is not approved at the first committee, then it could, and I guess there should maybe be another arrow here, would either go on to the next city committee, or if it was just assigned to that, well, and that's not entirely accurate, sorry. And have everyone look at this, but if it is not approved at the, let's say it's assigned to two city committees, if it's not approved at the first one, and it is approved at the second one, it would go on discussion, because in order to go on consent, it has to be approved at all committees to which it is assigned. So sorry, I'll have to revise these arrows before I send this out to you. If it is not approved at any of the committees to which it is assigned, whether it be 1, 2, or 3 committees, it does not go on to governing body. If it is unanimously denied at any of the city committees, even if it is approved at the first one and unanimously denied at the second, it will not go on to the governing body agenda. Are there any questions about that? Okay.
Jesse,
Jesse? Yeah. Go
Councilor
ahead.
Moore.
Councilor Meredith, go ahead.
This is really important and new. And so Jesse, yeah, a revision that's accurate is really paramount, because I think we've got to be really clear, because I want to avoid confusion and bad feelings. And so really important that we get this right.
I've been out and I was working on this earlier today, so it was.
Yeah.
I didn't
Yeah.
have a
So I
chance
just
to-
want to
I was thinking about
underscore.
it.
Yeah, I just want to underscore how important it is that we have a something that clearly helps us understand these new rules.
Councilor Cassidy.
I saw Aaron's hand pop up. Did you have something to that point?
I defer to you first, and I have a different idea to just mention.
Wonderful. I don't know, and maybe it's coming up later in the grand scheme of things, but there was also that discussion of order of committees of like the subject matter committee, then the subject matter council committee. We need to work on our different language for what we call all of our committees. But I think also recognizing that path there, we spent a lot of time discussing that as well.
Yes, thank you. I will mention that. So subject matter committee in city code, those are called city committees. So this is from our form 2 years ago. So I just edited a little bit. So we have city committees, and then finance, public works, and quality of life are called city council standing committees. So I can, again, I'll edit this a little bit, but so subject matter are also known as informally as advisory committees. Then we have the city council standing committee. So the first committee, if it's assigned to, let's say, public works and utilities, and then finance, first one would be public works and utilities, and then it would go to finance. So this is actually previously a custom, as we discussed earlier, where finance was the last committee to which something was referred. And that has not necessarily been followed over the last few years, but that was a previous custom. And it just gave it a little more time before the governing body meeting the following week to get everything final and prepared for the governing body packet. So there is a sort of hierarchy in some ways, not because one is more important than the other, but just in terms of process for which committees, the order in which an item is referred. Aaron?
Thanks, Jesse. I just wanted to comment, and I'm not sure if we're going to be able to depict it on here or not, but just the idea of referral and pausing are two of the things that are impacted here, or that this process is impacted by, right? So there might be essentially a hold at a particular committee along this, along these boxes, not in the subject matter committee, but in one of the council committees. And there also could be a referral if something was, say, found to have a financial impact that was not known to have one previously, and quality of life decides to refer something to finance. That's something that's now possible that was not contemplated previously.
Councilor Villarreal, Councilwoman Villarreal.
Thanks. I think there needs to be some clarification somewhere, maybe not on this flow chart, but how substitute bills play into this mix, because it's really not a reintroduction, completely new, like we talked about a governing body. There's still an opportunity to do a substitute bill or resolution. So I don't know where we delineate that or explain that, but that is an option.
Yes, and that substitute legislation is not contemplated in the procedure rules either, so we have to figure out how those would be handled, because we have not addressed them in the procedure rules.
Yeah. Okay.
Any other questions on this page specifically before I go on to bills? Okay, I can't see everyone's screen, but I will move on unless someone says something. So now we move on to bills, which are similar in some ways. A couple changes. we of course have introduction. The meeting after introduction is when we have that first public comment that gives the public a chance to weigh in at the very beginning on the bill, to see if they have any concerns, legitimate concerns that could certainly be addressed during the committee hearing. After that, we go to the first City Council Standing Committee. Once it is approved, after it is approved by at least one City Council Standing Committee, that's sort of the trigger for the city clerk to publish the notice of public hearing. Previously, also a custom that we used to have was that the governing body would have it on their agenda as an action item to approve this notice of public hearing. So we're taking that out and making it, creating a trigger for that action to happen. Goes to any additional city committees, and then we have it on the governing body agenda as a final action on legislation. So that's a new section on the agenda. So that'll be the public hearing, essentially. Also, same thing here. We go to Public Works and Utilities or Quality of Life first before it goes to Finance. There's no fiscal impact or it doesn't have any financial aspect to it, then it could just go to one or both of those other committees before it goes on to governing body. In this case, there is no consent, so it doesn't matter if it gets approved or denied at one of the committees, except that it does have to be approved by at least one committee in order to go on the governing body agenda. Down here we have the land use rezoning. Well, it's a bill, not a resolution. It goes to the Planning Commission for a public hearing, and then straight to governing body for a public hearing. There is no committee review on these land use cases. Councilor Villarreal, Councilwoman, sorry.
I think just the one thing I want to make sure is now that on the agenda under matters from city clerk, those descriptions of upcoming legislation or bills that we'll be hearing, that's what this is. The city clerk publishes notice of public hearing. Is that what it looks like visibly? Like what we have on our agenda this week.
Thank you, Councilwoman. I think that's maybe a question for Christine, but I believe that what she's done previously is post the upcoming public hearings that will be heard at the subsequent meetings. So if there are items listed on the agenda for tomorrow that say upcoming public hearings, they will be heard at the February 9th meeting.
Right. I think though you put it under matters from city clerk though. Is that right? Correct?
Yes. Sorry, Jesse, do you want me to jump in really fast?
Yeah, go for it.
Councilwoman Villarreal, that's correct. We formalized previously when I became city clerk, we started adding that as just an additional information kind of area for individuals to know what was upcoming. So it will be noted as upcoming, similar to the way you see it on tomorrow night's agenda. And it does have the publication date for which we noticed, and then also the date at which the public hearing will take place.
Got it. So that's what suffices for the publish of notice of public hearing. That's all you need to do, or are there other things that you have to do?
No, we also notice it in the paper as well, but that's just, again, some additional information that we provide to the public as well, and for ourselves. It's kind of like the committee schedule. That was something that didn't used to be on the agenda. I felt it was very important for us to include that for members of not only internal government, but also our constituents to kind of follow along with our process. So the publication date is actually the date that it's published in the Santa Fe New Mexican. And then it's on the committee, or excuse me, and then it's on the agenda with the committee process and then the date of the public hearing.
Got it. Thank you.
Thank you, Christine. Any questions on bills? Any other questions, I should say? Okay. Contracts, similar process that they have to go through the city committee process. One difference is that they are not introduced. They just go to the first subject matter committee, but they do have to be approved by at least one of those committees in order to go on the agenda. If they're approved by all the committees to which they go, then they end up on consent. And now I'm gonna, Aaron touched on this a little bit, but I put down a couple slides on possible motions that can be made either at.
Jesse, can I just jump in on the contracts thing really quick?
Yes.
I think a difference that people should be aware of, particularly in relation to contracts, but also in relation to some of the other stuff, well, resolutions, I guess it won't happen for bills. But if a resolution is only referred to one committee, or if a contract is only referred to one committee, and it's passed by that committee, under these rules, it will go on consent. Whereas before, most things needed 2 committees to go on consent. So sometimes things were being sent to 2 committees, even if they weren't really relevant to the 2 committees, just to get them on consent. So I think that's a significant difference that people should be aware of.
Thank you. And just a reminder that normally any contracts under 60,000 are, in normal times, I should say, any contracts under 60,000 are not approved by the governing body. And while we're in a state of emergency, all contracts under 200,000 are not approved by the governing body. Although I believe John provides monthly updates on the contracts that he has signed. Councilwoman Villarreal.
I have a question on that because there's some things that we see in committee and governing body of contracts and budget adjustments that are under 200,000. So it's kind of confusing me. It's a little inconsistent, and I'm trying to figure out when we actually don't see things and when we do see things. And right now it's a little fuzzy. So if we could get some clarity on that, because we made that rule based on the emergency order and specifically about things we needed to purchase related to the pandemic. And now it's like a lot of really important contracts I think we should be seeing that are then given to us 3 months later. So I would like us to make that a little bit more consistent. I don't know if it needs to be clarified right now, or if you can like let us know what how you all are making decisions about this and who makes the decisions.
I'll defer to Aaron since I don't actually deal with contracts.
Thanks for the question. So there definitely is one big inconsistency, but it's consistently inconsistent, and that is that budget adjustments are still at the 60,000 for all budget adjustments, and contracts are at 200. So though we did not change the budget adjustment authority when we changed the contract authority. So those numbers are inconsistent, but as related to budget adjustments, everything over 60 should be going to the governing body still, because we just didn't touch that. And everything over 200 should be going to governing body as well. Now and then there are intergovernmental agreements that require the governing body to sign, or certain grant ones that require the governing body to sign, regardless of the amount. And so we can't really override those requirements. Like certain state requirements require a governing body vote. So we can't override that requirement. So in general, we're trying to be absolutely consistent, and everything over 200 is going to the council. Everything under is not, but there are exceptions because some of the contracts we don't have control over those provisions, or that the other parties' criteria. In terms of who's making the decision, when it comes through my office, we are making a recommendation as to who has the authority to sign a contract. So often Marcos is looking at that, and sometimes it's a close call. So he and I will consult on those types of things if it's an unusual circumstance. And we have to try to figure out, like, what was this government agency saying when they said the person with authority, and they described the person with authority, and it's not entirely consistent with how we describe person of authority. So then we make a call. And if it's on the line, we generally say governing body. So we generally send things to the governing body if it's not clearly delegated to the city manager.
I guess I just see some more like inconsistencies around that. Because I recognize there's intergovernmental contracts, but there's other things that we're seeing that's under 200,000. And then there's other things I think we should see that are not coming to us that I think are relevant to policymakers having an eye on it. So maybe you and I can talk more about that offline, so I have a better understanding about it. Because the last summary that we got, there were some things on there I just did not understand why we never saw it, or if it was related to something we saw and then there was an addition or an amendment that we didn't know about. So I can talk to you about it. John and I have been talking about that, but I think what the ruling was, or at least was told to us, weren't we going to get those monthly?
Counselors, yeah, I think we're supposed to have a monthly or a regular report about anything in between 60 and 200. Yeah.
Okay. I hope we can get back to that as well. Thanks.
Councilwoman, I do just want to jump in on that as well. It would be very helpful for at least my office if there's anything that comes up on a council committee agenda, or if councilor chairs, when they're doing their revisions, if there's an item they don't feel should be going through the committee process or there's questions on, it would be great for us to know. I do know that at least in my office, when items come to the governing body agenda, occasionally we'll catch things and in discussion with the liaisons, it's either an amendment that was like the original contract was approved by governing body. So they'll process through the amendment so that it's consistent with what had been as not same topic, different context, but something that was already approved by the governing body would then be reapproved to the governing body. So I think we're working with staff and council liaisons to try to create consistency in that, but that might be one other area where you're seeing that. And we are, I think, working to make sure that there's consistency in that.
I do just want to
And
add
I see you.
a little bit onto that. If an amendment is less than 200,000, but the cumulative amount is over 200,000, we are directing those to the governing body. If an amendment cumulatively is going to be under 200,000, but governing body approved the original, that's been delegated to the city manager. So that's why that could happen. It could appear inconsistent, but it just really depends on when the signing happened and what authority that entity had at that time.
Can you put that in an email? Because that was confusing. Thank
Yeah,
you.
no, I can see why. So yeah, I can do that. Yeah.
Okay, thank you. So going on to the possible motions, these are all contained in the procedural rules, which I emailed to all of you. And just mentioning again that we are having hard copies printed that we'll provide to all of you in your mailboxes. If you want them snail mailed to you, we can do that as well if you don't go to City Hall. So we have approve, approve as amended. And so one change here is that at the City Council Standing Committee level, any amendments adopted at, let's say, the first committee will then be incorporated into that legislation essentially at the subsequent committee. So if something is approved as amended at finance, it goes to governing body. And there aren't any additional changes, the motion would be to approve as opposed to the way we previously did it. The amendments would have to be specifically incorporated. But now it's already incorporated if it's been approved at committee. So then the motion would be to approve with the assumption that or understanding the amendments are incorporated in that motion. At the committee level, we have deny. If it's a majority but non-unanimous, so if it's 4-1, 4-0, that would be 3-2. It would be a denial, but it would still, assuming it's been approved by at least one other committee, it would still go on to the governing body agenda. at the governing body level that if it's denied, it doesn't matter the level to which it's denied, if it's 3-2, 4-1, or 5-0, or sorry, 9-0 or 5-4, it's not going to be adopted. At the committee level, we do have this deny unanimously. So if it is if it is denied by the full membership of the committee, so that means a 5-0 vote, nothing less than that, it doesn't move forward to the next committee or to governing body, and that's not applicable at the governing body level. At the committee level, we have no recommendation. So if the committee desires, the motion can be to move it on to the next committee without recommendation. That's neither an approval nor a denial. And that's an important note to keep in mind, is that a vote of no recommendation does not count as approval. So for the purposes of getting something on the governing body agenda, if all the committees that it goes to vote no recommendation, it does not go on the governing body agenda. It needs to be specifically approved by at least one committee. And that's not a possible motion at governing body. You could also vote to refer it to another committee, either back to a committee to which it's already been because, for whatever reason, or to another committee that it hadn't been scheduled because maybe, as was an example earlier, maybe it's discovered that there is actually a fiscal impact, and now Public Works wants to send it to Finance, so they can that could be the motion to send it to Finance. Governing body can do the same thing. Can postpone to a date certain. However, the date certain is at a max the next regularly scheduled meeting of that committee. So there's really only one option for postponement. Same with governing body. If it's at the committee level and it's postponed to the next, let's say it's at quality of life, and the motion is to postpone it to the next quality of life meeting, any other committees or governing body agendas that it is on in between before the next quality of life meeting, those would then automatically be pushed out 2 weeks to accommodate this postponement. Postpone indefinitely, this is not applicable at the committee level, but the governing body could vote to postpone the item indefinitely. Robert's Rules defines this or characterizes this as a motion that disposes of the main motion without actually taking a direct vote for or against the main motion. And then you can lay on the table. And so this is can be used to delay the item that's being discussed to a later time in the meeting if the relevant staff is not available. They think that they can get them on in the next few minutes to delay it or to discuss it. Maybe there's some information that needs to be compiled, and so you can delay it till further down the agenda, and that's possible at both the committee and the governing body level. Are there any questions on any of those? Aaron, if I missed anything, please jump in.
I guess I would just say that I think this was pointed out earlier, but for the governing body, at least, these are not an exhaustive list. There could be more specialized motions, particularly about procedures. Like we could move to limit time of debate to 1 hour on an item or something like that. That's absolutely permissible.
Yes, there are additional motions. These are the ones that are specifically defined in the procedural rules, because they can't, for example, deny unanimously is not a motion that is in Robert's rules. So these are specifically called out in our procedural rules. If there aren't any questions on any of these, then I am done, and I will turn it back over to Aaron or the mayor, whoever has something else.
I think that concludes our scheduled agenda items. If there's any questions about any of the material, I think all three of us are here. But we're also happy to respond to emails, and we'll compile one email with all of this information and send it to everybody.
Anybody have a question that they didn't get a chance to ask? And all of this, these decks, are you gonna send the decks out to everybody as attachments? Good, that's great.
Yes, we'll do. Yes.
If you sleep on this and something occurs to you just tomorrow or whenever, why don't you route it through Erin so it's directly to the city attorney's office, and then she'll be the proper router of further questions if it involves Jesse or Christine or somebody else. Great. Thanks, everybody.
Yeah, thank you everyone for the training, and hopefully it was informational. We'll be posted. This is available on YouTube also. If you want to go back and look at anything, it will be available online. And then we'll look forward to the next training orientation session. So thank you all for joining.
Thank you.